aged father and mother, and the particular person will not.
Where are you residing now? Where are you residing now?
কোথায় আপনি
Sir, I am by profession doctor and my current.
Tell your counsel. Tell your counsel.
বলুন আপনি কি বলছেন বলুন
Sir,
আমাকে বলুন আমাকে
আমার মা ওখানে, আমার মায়ের বাড়ির ওখানে বলে আমার মা
আপনার মার বাড়িটা কোথায়
ওখানে সেম ভিলেজে।
সেম ভিলেজে কত যেখানে কিনেছেন তার
হ্যাঁ,
থেকে
পাশে, তার থেকে 100
মিলর বাই দ্য সাইড অফ দি বাই দ্য
So your building construction is ready, habitable.
Yes, yes,
it
yes.
is habitable.
So have they ever resided in that building? When was the building
আপনার বাবা-
constructed?
হ্যাঁ,
কবে কবে করেছে
ওটা 40 years ago। মানে যখন আমরা
this is a old building. I purchased the land along with the building, a portion of the land.
No, no, আমরা ওখানে থাকি, আমার মা বাবা ওখানে থাকেন, কিন্তু তার পাশে আমরা এটা আলাদা সেপারেট
সেটাই তো
বিল্ডিং
বলছি।
কিনেছি। হ্যাঁ, আমরা আলাদা মানে আমার মা বাবা ওখানে থাকেন, ওখানে আমার মানে বাবার বাড়ি। এবার এটা আমরা সেপারেট একটা মানে বাড়ি আর জায়গা কিনেছি, এখানে আমি সেটা আমার মা বাবা দেখাশোনা করছিল আমার অ্যাবসেন্সে।
Planets government appearing for Mr. Bhattacharya ensure that the affidavit of service comes, otherwise we cannot up.
Yes, 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 yes.
Yes, now, next.
এই আগে কিন্তু affidavit of service টা কিন্তু করেছে।
And serve this order and intimate this order to the advocate concerned today itself.
Instead of today, kindly permit me to do it by tomorrow. Why? Because it will come in the server. In the evening, I will get it.
Yes.
আরে দেখে নিয়েছিস তো? এটা আর তো কিছু বলার নেই, সেটাই বলার তো।
এইটা তো to show appear করছে Mr. You are for the
original writ
petitioner.
petitioners.
Read petitioner. Appears না, না, না। এইটা চেঞ্জ to respond to 6 আসলে তো এটা কি respondent or season what was the defect?
The defect was that the name of one Millard, just 1 second, Millard.
But the appeal was preferred by someone who was not a party to the original writ petition.
Right. This appeal was filed by one Shukendu Kumar Mondol. And Millard, I have indicated in the application in the particular Millard.
Paragraph
Paragraph 3 to 6.
Millard, this has been indicated in paragraphs 3 to 6. 3 to 6. 3 to 7. I say Millard 3 to 7.
আর কি দিন
এখনো অ্যাপ্লিকেশনটা চাই।
রিপিট করে দিয়েইছে ও বলেছে যে ওখানে এসছে 2023 এখানে বলেছে 23 petition স্কুল হয়েছে তোমার এটাও ফাইল করেছে removing the defects in the cosmetic. How can we change your name in the disposed of writ petition? How can we impede this person after disposal of the writ petition? Writ
No.
petition, when was disposed of, you came into power.
I,
You became the chairman or president, whatever
yes,
it is.
yes.
That was in
But he
2023.
is no more, therefore he cannot file the appeal.
No. The present incumbent.
Present income, yes.
When did he assume office of president? When did he assume office as president?
Milord, he had assumed the office that I have stated.
2023.
Yes, 31st January.
Now in 2023,
Yes,
2025, when the writ petition was disposed of, Sanjay Mitra didn't have the locus to carry the proceeding.
yes,
Hence, you preferred the appeal.
yes, because he is not
Now,
there. Yes, yes,
the
yes,
difficulty
yes.
we are facing is, Mr. Bhattacharya, how can we implead you in a disposed of writ petition as a respondent?
No, your lordship may, Milord, your lordship may kindly consider I have only two things to say. First of all, Milord, an appeal is a continuation of a proceeding of a learned trial court. And secondly, supposing the post in which I am there, kindly see in the cost title I have indicated the post in which I am there. Therefore, the post of President Technical Supervising Staff Association.
Sir, let them treat this application as an application for leave to file. খালি ওর নামটা
বল সেটা,
বিশালই হবে।
হ্যাঁ, তুই বল সেটা। তাদের কিছুই করা যাবে না, তারা তো তোরাও কিছু করতে পারবে না, আমিও কিছু করতে পারবো না, সেটা this respondent number 7, his name should be deleted.
Who is Sivan?
He was Sanjay Mitra.
Sanjay is respondent number 6.
I find in the cost title of the
Respondent number
7. Well, I'm just handing over. Your lordship.
দেখি আবার ফাইলটা তো
That.
in the appeal cost title
Yes,
you have
yes,
incorporated.
Yes, I'm grateful.
My lord, perhaps there is no necessity, my lord, to remove his name since, my lord, he was a respondent in the original writ petition.
No, the Sanjay Mitra, since had retired, his name cannot appear in this particular cost title. That is my
We
concern.
are not disturbing that. Let it be as it is. We have
Leave it to
clarified
mine.
that you will appear in the proceeding in place and stead of Sanjay Mitra who has retired.
Very good.
We cannot touch the writ petition now.
No,
It
no,
has
that's
been-
it. But I have also learned something.
Today you have learned, we are learning every day. That is the difference. কি করবে? Fees দিতে বলবে? Yes.
That's in it.
That plus.
Yes, call the next.
This is my appeal.
And on the last occasion, I appear for CBI. I submitted the status report with the specifics.
Millet,
আমার কিছু observation করতাম। Inspector of Anti-Corruption
আমার কেন ফল করছে পাগল নাকি মাই অ্যাপিল কি করবো
Yes,
Millet, I am challenging the order passed by the learned single judge, manner and the way this has been, the investigation was handed over to the CBI. Although Millet, the CBI has ended up this investigation and filed the report by form of a charge sheet, I believe what is not charge sheet. I'm sorry.
Sanction.
Only for the sanction. In respect of the Millet, respondent number 4 hearing. But kindly have a look. The manner Millet this has been dealt with. Millet, prior to that, I just give a factual background of the case. Yes. Millet, two things. There is an allegation against Millet, some of the person that they are taking the money from the market in lieu of the job. Millet, as and when we have received the Millet complaint, Millet, we have started a case. Millet, Lordship would see the impugn paragraph, impugn judgment is that starts from the 112 onwards.
there were 2 writ petitions.
There were possibly 2 writ petition, 1 writ petition has been withdrawn. I have seen in the page number 113.
So this is this writ petitioner he appeared. Who is the advocate of the writ petitioner?
I am the advocate of the petition.
Writ petitioner, which advocate appeared? You are the CBI, na?
No.
no.
He appear on behalf of the petitioner.
I am the writ petitioner, my lord, victim writ petitioner, my lord. At my instance, my lord, the CBI investigation was ordered. And my lord, on the last occasion, my lord, only one thing, my lord, on the last occasion, my lord, it was submitted by Mr. Sengupta that he is aggrieved by the observation made by the learned single judge.
Correct,
He is
Millet,
not, he is
correct.
not placing, he is
Correct,
not
correct.
placing the appeal on merit.
No, correct,
Otherwise,
correct,
my lord,
correct.
he cannot maintain the appeal.
No, I
Let him address on this issue.
Millet,
Whether
I,
or not the
since the
observation
appeal
is
is on the board, I cannot maintain the appeal.
Yes.
We have not heard him also.
Yes.
Today we are hearing.
Just pointing out to your lordship, my lord, that was the last of the occasion, my lord, he submitted that.
On the basis of the writ court order, investigation was handed over to CBI.
In
Now,
the,
CBI has already conducted investigation, filed the charge sheet.
No.
Not
No.
filed the charge sheet.
CBI
CBI concluded the investigation, asked for a sanction
Asked for a sanction.
from the Honorable Speaker because the main accused was an MLA.
Now, my lord, the sanction has been
Sanction
granted by
has
the
been
court.
granted under section 19 of
Now, my lord, as on date, my lord, sanction has been. My lord, as on date, my lord, sanction has been
MLA, respondent number 6.
6. My lord, as on date, my lord, sanction has been granted by the court, and he is no more in this world. Say respondent number 6.
Oh.
Now, my lord, now, my lord, there are other accused. There are other accused, but so far as respondent number 6 is concerned, he.
When did he expire?
My lord, on the
Just
last-
before the day, just after the
last-
day we took the adjournment.
Yes, on the last day, my lord, you last heard the matter. Next day, he expired. And more so, my lord, so far.
Tiwari, the other persons concerned in the investigation are not parties to the present proceedings.
No, no, no.
So we are only concerned with
Yes,
them.
yes, yes. And only one thing, my lord. My lord, so far as my lord, this officer is conduct, my lord, he has not placed it on merit. Till date, my lord, all documents has not been handed over to the CBI.
We've seen that in the report.
I will deal
Yes,
with.
yes, addresses.
Now, Millard, kindly take trouble to see Millard, page 112. What is
So
troubling
what
me,
is
Millard?
the hot haste in this matter?
Yes, Millard.
Why we are taking it up so early? You can wait. You can wait till after vacation.
No, Millard, two things.
We are taking up motions which are pending in the list. So can you not wait till the reopening? Because this will take some time, na? You will make your
Not
argument.
much, Millard, not much. If your lordship so desire to take it up after the vacation, I have nothing to say. Only two things I would like to point it
There
out.
is no urgency involved, na? You are only concerned with the caustic remarks according to you
Who is
which
my
were
client?
made against the officer.
Mr. Shengupta,
Mr. Bose.
you
You are-
address us.
I'm sorry, Millard.
Address us.
Why you are looking that side?
No, Millard, this sometimes we have to respond to the sledgings. We have learned from the cricket field.
No, this is not the cricket field.
No, it is not, Millard. Sometimes it has to be.
No, don't.
I'm sorry, Millard. Yes, Millard.
Your appeal is limited to the remarks made, caustic remarks against you. You can't challenge the transfer
This
of
is
the case.
no,
from the
no.
ACB
This
to
is
CBI.
correct, Millard. Correct. Your lordship is absolutely correct.
What is the urgency in that?
Two things I would like to point it out. The remarks which has been made by the Millard learned single judge, and on that score, the matter has been transferred to the CBI. Millard lordship knows two things. One, the registration of the arrest, then come the question of arresting a person. Arresting a person is not at all a mandatory. The single judge proceeded on the basis, since we have not arrested the person, therefore this is the good ground to
Which paragraph?
38 onwards. Kindly come.
Huh?
38, page 38. Paragraph 38, which is starts at Millard from, wait a minute. Yes, 129 onwards. Now, may I place this, Millard? Yes, Millard.
Your officer's name is?
Anupam Das. And one more thing, Milord,
We
before,
keep it on the reopening date.
not even, exactly on the reopening date, one day after the reopening.
We have heard the learned advocate.
Milord, kindly also direct them to hand over the documents.
Milord,
Terms
since
of
they
the-
have,
No, no,
I am asking
we have
myself,
report.
since they have concluded the investigation,
No, no,
and
no,
this
not
matter is
concluded.
under the challenge, Milord, I am challenging the whole order.
No, you
No,
are saying only the remarks
No,
against you.
on that,
You are not challenging the factum of transfer of the case from you to CBI.
Milord,
So you hand over the case.
Milord, I have to, since it is observation of your lordship,
Do it
but
now.
I am not challenging the part of this order. I am challenging the order as a whole. Now, this is one part. Second,
What kind of submission?
this is number one.
Mr. Sengupta, kindly appreciate. REET court has issued substantially two directions.
Correct.
One is transferred and conclude, and the other is your officer may not have acted in terms of the regards of the statute
Lord-
which he ought to have.
Correct.
Yeah,
Lordship, absolutely. Lordship,
So your argument will be that my work can be criticized, but I cannot be held up to a person having collusion or any other nexus with the alleged culprits.
Correct.
That will be your argument.
correct. That apart.
So now when the investigation has proceeded, you are not standing in the way of investigation.
Certainly not.
So
Certainly not.
Then what is the problem in handing over the document?
Very well. I will be handing over. Well, since the two things. Since this is fallen.
Mr. Chakraborty, which document do you require?
Milord, actually, the report actually reveals
Now you are no longer
the
in.
case diary and other documents are not handled.
They have concluded the
That is the
this
report.
investigations.
Then Mr.
But the other
Chakraborty,
accused are there. Apart from Tapas Saha, there are other accused.
the investigation pertaining to all the accused has been concluded, and it was sent.
Not concluded all the accused, but other
Wait
documents. It is still going on because your lordships are aware. When we get a sanction under Section 19 of the Prevention of Corruption Act, then we file the charge sheet or a supplementary charge sheet.
Hmm.
That is the procedure.
Hmm.
Previous sanction is necessary. That we have obtained from the speaker. That is speaker's
So
sanction.
is sanction required from the any other?
No, they are the
Yes.
private one.
Only private.
Only on
Only
this
on
one
the
or six?
MLA. On the MLA, that is
So
speaker.
now you can proceed.
Yes.
So which documents are lying with him?
Mainly case diary and other relevant documents which have been disclosed in the report.
So Mr. Sengupta, why you are not handing over those documents?
Milord,
No,
if your
no,
lordship,
this was passed.
because I have communicated the Milord, the CBI, that since we have challenged the Milord, the order as a whole, Milord, therefore we are not handing over. This is number one.
You are challenging the handing over of investigation to CBI.
Yes, as a whole.
So,
Because two things. One, there is a parameter set by the Supreme Court. Lordship knows far better than I do. In what manner the CBI can investigate.
Arey sir,
On
you
the last
are
question,
not
what
the
you have
accused.
submitted, my lord?
Mr.
You are
Tiwari,
the
kindly have a look.
officer.
But you are changing
wait.
your stand.
I am not changing. This
Yes.
is my appeal is there. I am not changing my stand.
Mr. Sengupta, you are from the very inception we have been hearing this,
Smile.
that please expunge the remarks against my officer.
This is one. Second of all, Lordship kindly test.
The second which you are arguing, you cannot argue that.
No, Milord,
You were an investigating officer. How
Correct,
can
Milord.
you say don't take away the investigation from me and give it to CBI?
very well, Milord, kindly appreciate what is my understanding. Kindly appreciate for a moment, Milord. Milord, today this order, if I don't, Milord, Lordship kindly takes it up this one and read as a whole. This will be treated as a precedent in order to, Milord, handing over the investigation to the CBI. Milord, I have challenged the same, Milord, because of the reason that it should not be treated as a precedent. This is the one thing, because this will become a.
That will be considered.
That's it.
If we ultimately expunge the remarks,
Right.
then this instance will not be treated as a precedent or not, we will consider.
Very well. That is what I'm on. Lordship, kindly. Yes.
So then why you are not sending the documents to them?
Lordship, I am sending it.
Is it with you?
We require 3-4 days, Milord. We will be handing over.
Sir, kindly see when the order was passed.
Wait,
18th of April 2023.
And what is the locus of Mr. Tiwari?
No, I am the person of the victim.
No, he is not the FIR. He is not the Milord accused. Or he is not the Milord defect complainant over here. Mr. Tiwari is not the de facto complainant, my lord.
I am the
At,
victim.
no, it is not. My lord, not at his instant, my lord, any complaint was started. Oh.
Only 11:30.
Hobe.
You should have raised your voice after 2 p.m. Here in the morning session of the Mr. Chakraborty, whom the papers has to be handed over.
Lord, actually the report reveals the case
To whom
diary.
he will hand over.
Case diary. To whom? Lord, the SP CBI anti-corruption branch.
So we give it, he will hand over just now to you. Finished, we will record.
To us.
Just now.
Your advocate on record.
My lord, whatever records we have, that is the incomplete record. There are 3-4 things which we have collected from the Malkhanas, like the mobiles and other things. So, my lord, we have to collect it and then we can hand it over. That's the whole difficulty.
No, they are wanting to hand over the case diary.
Oh yes,
along with
we
the
have to, my lord, we have to tally with the Malkhana's record and then we can hand it over. There are some documents and instrument like phones. These documents are there. I am not standing in the way, my lord, to handing over. Lordship, kindly direct. I will be do so.
Yes, to whom he will be giving?
Superintendent of Police Anti-Corruption Branch CBI, who has affirmed this affidavit of status report.
Able to shop record case diary along with other relevant records of RCC. Specification.
Earlier, is there any direction? Sorry,
Report.
Oh,
By CBI.
I'm sorry. May I get a report of the same, my lord, since it has
So
been.
that is a confidential document. There is a serious
no.
apprehension of destruction of evidence.
Who will be? Who will be
report
distracted?
Mr. Chakraborty.
You know, confidential report
Who will
regarding
It was a
this
confidential report.
status report, that if it is handed over to them, there is apprehension of destruction of evidence.
Who will do so? The state will destruct the evidence.
Doing it for the last.
Unheard of. Unheard of. The state will destruct the evidence. my lord. Yes, of course. At my experience, it is unheard of. The state will destruct the
You
evidence.
have lesser experience possibly.
Definitely, sir.
Of course.
In considering to your
Mr. Sengupta, learned advocate, appearing for the appellant, submits that the appellant in the present appeal primarily challenges the remarks made by the learned, remarks and observations of the learned single judge pertaining to the appellant, namely,
Anupam Das.
Mr. Anupam Das,
Sri Anupam Das. You are working as,
Inspector of Police Anti-Corruption Branch, West Bengal.
Inspector of Police Anti-Corruption Branch,
West Bengal.
West Bengal.
West Bengal. Stop records reveal that pursuant to an earlier direction passed by a coordinate bench of this court, a status report has been filed on behalf of CBI. Stop. A perusal of the said Mr. Chakraborty, learned ASG, appearing for CBI. Now, drawing our attention to the said status report, Mr.
Para 15 and last para 19. Para 15 and 19 will reveal everything.
19 what you have stated?
19 is no non-cooperation from the state.
We are not dealing with that now. Today we are only drawing our attention to the status report. Mr. Chakraborty learned ASG appearing for CBI submits that, quote unquote, till date, the anti-corruption branch, comma, has not handed over the case. এখানে আছে, paragraph 15 এর last 3টে line. Till date, ছোট্ট করে underline. ছোট্ট করে mark করে দিয়েছিলাম। Till date থেকে RC3 2000 stop. Mr. Chakraborty further informs us that upon completion of investigation, sanction was sought for this respondent number 6 has expired. Oh. Mr. Chakraborty further submits that upon how can investigation has not completed unless you get back the after sanction is obtained, you will continue against the others.
Yes.
So you cannot say investigation has been completed.
No,
Line-টা কেটে দাও।
I am not submitting that. I have
Stop,
submitted after sanction.
Is the matter for further consideration in the daily supplementary list under the same heading in the daily supplementary list of this court on 16th June. In the meantime, the appellant is directed to hand over the case diaries along with all other relevant documents. Evidence collected. Also transmit the evidence collected. Also what is paragraph 1 you have written? All evidence directly or indirectly. It is a very vague statement, Mr. Chakraborty. Paragraph 1,
Para 1 of the report.
yes. Last 3 lines kindly read.
Investigating officer shall transmit the entire case diary and all evidence collected directly or indirectly in his custody to the CBI. The CBI shall take over the investigation and conduct the same
That
with
is
others.
separate. What do you?
That is para 1. That is para 1.
So we are wanting to know what case there was case diaries you have said. How many cases were incorporated? Separate cases were there or single case was there?
Single case was there.
So
Ultimately was
there will be one case diary in that.
that is CBI after getting the permission from the Honorable Court registered an FIR and proceeded with the investigation. That has been mentioned.
It is a reflection of
Okay, so-
page paragraph 45 of the Talco Judge. Page 131.
In the meantime,
Para 2 reveals after handing over the charge to the CBI, what is the FIR registered by the CBI?
131.
Number has been mentioned. What case?
এরম লেখ।
Para 2.
কি লিখেছো? Please the matter for further. In the meantime, the appellant is directed to hand over the entire case diary and all evidence collected directly or indirectly এটাই বলে দিই? to the superintendent of police, CBI, ACB, Kolkata
নিশ্চয়ই বলতে তো
within a week from date. Within a week from date. Stop. Superintendent of police, we don't accept within a week from date. List the matter for further consideration on 16th.
Only one adjustment. I would have Millard submitted that the manner this has been transferred to the CBI, it will be treated as a precedent.
Primarily, we have said that your primary challenge is expansion of the remand. We have not stopped you from.
Connecting matters are investigated by the CBI.
Yes,
And I will also show how Mr. Tiwari is
Mr.
having-
Sengupta, list is before us. Tell your officer
Yes, my lord.
that he will give half of the records and half he will keep. If we find that, then he will be in problem before us. So let him act as the court directs. Let him hand over all the documents which were required for
After
conclusion.
the passing of the lordship's order.
Better, because he need not be emboldened by this fact that the matter is being kept.
No, my lord, I am not standing in the way, not even.
Yes, okay, next. Yes, yes, yes.
I appeal, my lord. This is against, my lord, an order passed in contempt petition, my lord. My lord will recall this was, my lord, heard by my lords, my lord, where, my lord, there is an order directing the financial institution not to take possession. However, before the order was passed, the possession was taken. When this fact was brought to the court's notice, my lord, the court directed me to give the possession back to the borrower and held me in contempt. Now, my lord, it would be apparent from the
Which
order
order
itself.
are you challenging?
I'm sorry, my lord.
Which order are you
Yes,
challenging?
I am. The order impugned is, my lord, at
6
page number
September.
23, 6 September 2024.
Matter was taken up at 2:50 on the day when there was a not to attend or something, and 2:52 you went and took possession.
The
You didn't
possession was
appear and
before.
went and took
The possession, this started at 2:20. In fact, it started from the morning itself. And, my lord, before the order was passed or communicated, my lord, communication came next day. The possession was already taken
Came next day because there was a technical glitch.
because they could not communicate. But fact remains, my lord, the order was passed when the police has already taken the possession. So how can, my lord, subject to, my lord, what my lords feel, my lord, how can I be held in guilty of contempt? And the difficulty here is today I have been asked to give back the possession. DRT, my lord. Now, for the difficulty that I am facing today is that my section 14 goes, I have to go back again and apply for
There's some proceeding which was initiated before the DRT.
they file a section 17
What
application.
happened there?
It's
My lord,
pending.
So
yes,
was
your
some
lordship.
order
Lordship, there
passed?
was an order of stay, your lordship. On the last occasion, your lordship has
By the
said
DRT?
during all the, yes, your lordship. Lordship, these are the
That I cannot take
orders.
possession again. Now,
Lordship
this
is
order by which I
It was heard out.
has to be.
Lordship, if I may submit your lordship, my lord, the order which was passed by the Honorable High Court says that the DRT will take its independent stand. We will have to approach the DRT by the strength of this order. My lord, we have challenged the order passed under section 14 before the DRT. My lord, the DRT has said that there will be an order of stay and the possession will only be handed over after, my lord, there will be a leave from the tribunal. And till date, my lord, the stay is being extended. They have not yet filed their opposition. And my lord, one
pending here.
and my lord, they have not challenged the order which has been passed by the DRT, which has granted a stay again. My lord, now, and my lord, they have also filed their affidavit of compliance, my lord, and the final order which was passed in the contempt proceedings are there with me, your lordship. My lord, on one hand, they have complied, my lord, now they are challenging the same. And my lord, DRT has already,
Contempt disposed of.
yes, your lordship.
Where is that order?
Lordship, the order they have not annexed, but I have that with me, Your Lordship.
Order of
Lordship, this is the final order.
the order, my lord, by which contempt was disposed of is 13th September.
And it is.
Then
This is the
what
order.
remains?
My lord, nothing.
This appeal has become
No, my lord, it
infructuous.
is not subject to correction, my lord. Because, my lord, the order impugned is the real order by which I am aggrieved. Because by this order, I have been directed to hand back the possession to the borrower, my lord.
No, but you've accepted the rule has been discharged.
Yes,
You've not
my
said
lord,
anything.
my lord,
there.
I
Come on,
am
Mr.
sort
Singh.
fortified by judgments of
What
Apex
45?
Court, where, my lord, the courts have held under the threat of contempt if I am to comply with the order. This does not take away my right to challenge the order subsequently, but it's pat on the point. I should satisfy my lord on that aspect that after complying with the order, I do not lose the right to prefer an appeal against that order.
How you are prejudiced now?
Yes, I am prejudiced because, my lord, I had taken possession pursuant to order of the London Magistrate under section 14. By the order impugned, I have been directed to hand back the possession to the borrower. Today, first prejudice is that I have to now restart the process by filing section 14 application. Because by this impugned order, I have been directed to hand back the possession. First prejudice. Second prejudice, my lord, by the order impugned, my lord, all subsequent steps have been declared a nullity because in this subsequently, my lord, when there was no stay, it was sold to an auction purchaser. A third party right has been created now. Now, this is also declared to be a nullity by this impugned order. These are the two prejudices, my lord, I am facing today.
My lord, regarding the sale, I would submit before the DRT, they have submitted that they bought for the want of bidders, there has not been any sale, my lord. I have given the
Yes,
order.
on-
Now, my lord, that the sale is done, my lord, nothing is recorded before the DRT, my lord. We don't even know, my lord, when the sale took place. My lord, the sale notice which
there
was
in my
served upon us,
application.
my lord, we have challenged the same. They have said that no bid was received.
Oh, that was
Now, only Malad, the writ in the writ, Malad, we have challenged the order passed under section 14. Malad, they were directed to restrain their
Where
hands.
is
Malad,
the parent order passed in the writ petition?
writ petition. Yes,
Yes,
Your Lordship.
You have annexed that?
yes, I have an ex that's at page 107.
108. The
107 is 6th March 2024 order, my lord.
You are the owner, Manoshi Mondol.
yes, Your Lordship.
And you are which bank?
I am not a bank.
IIFL,
I am a financial institution.
institution.
I am not even a bank.
Oh,
The maintainability of writ was another issue, my lord. That's I'll not go into at this stage, my lord. Subject at all.
so the court restrained them from dispossessing you.
Yes, Your Lordship.
This order was passed on 6th March 2020.
Yes,
There
ma'am.
was a resolution by the Incorporated Law Society, my lord, for which they have.
Just a moment.
Yes.
Then the matter came. Then when was the contempt filed?
My lord, contempt was filed, my lord, after a period of 2 months.
So when was possession taken over by
6th
him?
My lord,
March.
6th only. On 6th
Same
only, possession was taken. My lord, this order was passed at 2:52. My lord, the live streaming was going on, my lord. My client was there. My client intimated that the matter is being taken up by virtue of the resolution, my lord. They chose not to appear. And my lord, since I was in crisis, I placed my case,
They
my lord.
chose means this authorized officer was a party to the
Yes, Your
proceeding.
Lordship. Yes, Your
He was
Lordship.
respondent number.
My lord, he was respondent number.
Was
My lord, he
very
was respondent
now
number 4.
when the court was in the process of
Yes.
passing this protection, possession was taken over.
my lord, not actually, my lord, from the live streaming, it would appear that
That it was subsequently.
it was subsequent.
So the possession, what is the property? How many land?
It's a land with building, it's a house. My house where I'm residing, your lordship.
So the possession, you were dispossessed.
I was dispossessed.
Very good. Now, what is the present situation?
Present, my lord, I have been restored back to possession.
You have been restored back
Yes.
to possession on the strength of the order passed in contempt.
On the strength of no, your lordship. On the strength of this order, we were first given back our possession. Then
When did you get back possession?
my lord, before 13th of September, they have filed their compliance. My lord, before that only,
Compliance
my lord,
was filed on 13th September.
on 6th, your lordship, we got back our possession. Page 186.
On 6th itself.
Yeah, 6th of September
Yes, 6th
2024.
September was 6th September.
6th September 2024, my lord. Page number 186, your lordship. 186.
So this was done after the contempt was filed.
This was done after the contempt.
When was the contempt filed?
Lordship.
Contempt first order was passed on 6th of September.
No, there has been.
I have prepared, but I have
just let
prepared
us
a list of
understand it.
dates, if my lord wants this.
That
Well, all the orders of the contempt application are not annexed here, your lordship. Contempt was filed on.
No, 6th September, your possession was handed over on 6th September, page 186.
Yes.
That was pursuant to any order of the contempt court.
Yes, your lordship. The order which my learned
6th
friend is
September
What
challenging.
is that order?
That-
Pursuant to which order possession was taken?
The impugned order, my lord.
Yes, your
Order
lordship.
dated 6th
6th
September.
September.
On that day at 3:30, my lord, possession was handed over to me.
No, prior to this, there must have been certain other orders passed in
My lord, there
contempt.
were certain other orders. My lord, the court was dealing. The court has called for, my lord, for the documentary evidence as well as, my lord, for the video footage, my lord, from which the court could ascertain that the possession was taken, my
Where
lord.
are those orders? How many orders were?
My lord, there would be at least, my lord, 5 to 6 orders prior to this.
So that you have to show to
Yes,
us.
your lordship, I'll
That's
produce.
incorrect, my lord. May I assist, my lord? May I assist? My lord, on 6th
There
of
must
March,
be at least one order.
My lord,
directing
well,
affidavits directing affidavits because we had filed an opposition, my lord, pursuant to the order in the contempt proceeding to show that the possession was taken before the order was actually delivered. So that affidavit I have annexed to my. So order was passed on 6th of March, restraining me to take possession for next 15 days. On 6th of March itself, the possession was taken. They subsequently, my lord, filed a contempt in September. The contempt on 6th of September, the court saw after affidavits and directed me to hand back the possession
no, no.
because
Yeah, of course. Now the 6th September order, when was rule issued against you? That
Yes.
order is not before us.
Lordship, there were 5 to 6 orders prior to
19th
that. The court has
July order
called for video
by which
footage also.
rule was issued 19th July and the rule was made returnable. I read a copy.
So your argument is that though rule has been discharged, now we should interfere for what? What do
Yes.
you want?
Yes, my lord. I want because I've been called upon to, my lord, purge the contempt because the court came to a finding that
What is the existence of this order? This has merged with the discharge of rule.
no, my lord, subject to correction, my lord.
What correction? Show us which
I-
judgment you are referring.
আমাকে ওটা দাও একবার।
Well, one thing, our contempt application was filed on 8th of April 2024. Well, the impugned order is of 6th of September 2024. In between, Mala, there were series of orders.
You speak with.
Kindly consider this, my lord. It's I read a copy down. Kindly, my lord, comes to page 4. Next judgment of
Judgment.
2005-7 SCC page 2005-7 paragraph. 57, volume 7. Page 4, my lord. Second paragraph is what I would rely, my lord.
Where is your compliance report?
My lord. The compliance, my lord, will find
Page
page
186.
177. Annexure E.
I want to see this.
The order was the order will be
Mr. Singh, what are you asking for? You want to take back possession?
Yes, because unless, my lord, I am held in contempt, I cannot be called upon to hand over the possession. The finding of the court that I am in
What happens
contempt.
to the order of the DRT?
DRT, my lord, DRT, my lord, when the order of DRT was passed,
No, now the interim order.
interim order is extended because
Right. So what happens if we are to give back possession to you? Are we not also superseding the order of the DRT, which is the tribunal with power to deal in such
my lord,
cases?
the DRT is subject to correction. The DRT's order was in light of the High Court's order directing me to hand back the possession, because if my lord sees the DRT's order, the DRT says that I will not take possession, whereas my possession was legally taken under section 14. Now, where I am aggrieved.
to argue that point before the tribunal.
We'll give you that liberty. We'll give you that liberty. You go and
Today, my
argue
lord,
this point
well,
before the
today the clock cannot be, because the third party right has been created in between. The property has been sold to a prospective, my lord.
So that you will argue in the DRT. What
Today,
is
my
it?
lord, kindly appreciate the difficulty going before DRT. Two things. One, the court has found me guilty of contempt, when in fact, my lord, could not have been, because the order was passed subsequently. So there cannot be a question of, my lord,
You have
contempt. There has to be
understood
willful disobedience.
You could have understood had you come to us immediately after the order.
We have come.
After the rule was issued, you filed a compliance, you abided by the order, handed over possession. Then in terms of the order, they went to DRT, obtained an order in your presence. What more do you want?
Kindly considers, my lord, the order is passed in
So
contempt.
be prepared
Within
for
24
exemplary
hours, I was directed to hand back the possession. And I did so within the course of the day. Could not have gone into appeal. Within 24 hours, I was directed to hand back. And my lord, that was the order of the court in contempt.
A rule was issued on 6 September.
Yes.
Your
And I was.
compliance report was filed in page 186.
Yes.
12 September.
My lord, the rule was issued against the police authority since they were not appearing. My lord,
Your
rule was
conduct
not.
does not seem to be proper.
Malad, the rule was not issued against Malad, the IIFL. It was issued against the police authorities since they were not appearing from the first instance.
Where is that order? 6 September.
They have no prior to that. Malad, they have not annexed.
Now, no rule was issued against this officer.
No rule was issued against this IIFL person. They were all along, my lord, proceeding. The rule was issued against the police officers.
Where from we will come to know that?
My lord, I'll be producing all the orders, my lord, on the next occasion, any day, if your lordship. If today your lordship keeps it at 2, my lord, I can bring.
We can't keep 2, 3
Lordship,
for
lordship,
everybody's
lordship,
convenience.
Whatever
To
is.
file a short affidavit enclosing all the orders passed in the contempt application since the date of the
Yes, your lordship. Lordship will see that they have filed the contempt
Sir,
application on
see,
18th
we'll
of
have
November.
problem. If we find rule was not there, you better consult your client. Don't ask us to impose some heavy cost upon you for
If there's
disturbing
actually
us.
no rule against you,
If it is a fact, then you are trying to upset the interim protection which they have now obtained from DRT in an independent process. In an independent forum, they have gone. Please apply your mind.
Lordship, they have filed the appeal on 18th of November. The order was
To
passed.
file a short
Lordship,
affidavit,
I'll just proceed.
chronological facts along with the dates of the orders.
I will.
Near no.
Let's see.
on these points,
6, 7, and 8 has come on my instance, my lord.
where which I have mentioned because my name does not appear in the order sheet, and I have served copies on all. তিনটে আছে দেখুন পরপর 6, 7 and 8.
Inadvertently,
I'm great.
I appear on behalf of the appellant. Your lordship on the last occasion passed an order. Now, my lord, permit my learned junior to admit. I think he should address my lord. My lord, and this is the affidavit of service. Your lordship, my lord, directed. You can.
I beg to appear for the state, led by Mr. Ansar Mumbai.
Last occasion, Lordship, my lord, our prayer before this honorable court, my lord, they are not maintaining transparency from the very beginning, my lord. My lord, at the outset when the matter was taken up,
which order you have challenged?
my lord, we have challenged, my lord, the order dated
24th March 2025 at page 44 to 47.
Order dated 24th of March 2020. 24th of March 2020.
The bidder total.
Page 153.
153 to
153 to 156 of the stay application.
Where is the order passed in the other appeal? That MAT 1826?
My lord, that is lordship will find from my lord,
Page
second bench
93.
order, page 93.
So it originated from what?
My lord, originated from page number, lordship will find from 89. Here, my lord, the examination was taken place in the year 2017.
Very good.
After a considerable period of time, when we moved this writ application, the stand taken by the Panchayat Authority of Murshidabad.
No, let us
Lordship.
go a bit slowly.
Lordship.
Examination notification was in 2017.
2017.
Where is that notification
I'm
first
showing
to
you.
us?
That is
49 to
page
56.
49 to 56.
Page 49.
Yes.
49.
You are for the state.
State, led by Mr. Ansar Mandal.
Eh?
Led by Mr. Ansar Mandal.
21st September 2017.
Here contenders for the
District level selection committee has reconstituted. Decided. So on the basis of this, you applied.
Applied and the withholding result for a considerable period of time. In the year 2021, we moved the writ application before this honorable court, page 89. When the plea taken by the authority, my lord, everything is missing. We are not in a position to do that. De novo recruitment process is required to be met. Page 89, lordship, kindly see.
9 to 92.
Now against that
My lord, the mandamus appeal.
was preferred.
Here, my lord. The
This is
state-
after the written examinations were over.
Yes, ma'am.
When was the written examination made?
Test was held on 22/7/2018.
22/7/2018.
22/7/2018.
2018.
Now the writ petition was filed by you, first writ petition.
Yes, ma'am.
The first writ petition was filed that you published the results.
Publish the result.
Then the state said that everything has gone missing.
Missing.
Then what did the single judge say?
My lord, kindly see.
That you apply afresh.
De novo process to be initiated and age to be condoned. And my lord, fresh proceedings.
Against this, they preferred appeal.
We prefer it.
Achha.
Page 93.
Now in appeal, what was said?
My lord, the appeal, lordship, my lord, when we raise the question how the OMR seat are missing, how the other things are there, my lord, how it is possible, then my lord, they come forward with a new plea. Yes, each and every documents are lying with us. My lord, this is our mistake. Then my lord, the honorable court was kind enough, annoyed, directed my lord, the advocate general to be in the court. Then my lord, finally, this decision was taken,
Process should be
completed
logical conclusion.
within 4 months. Logical conclusion. I pause for a moment, my lord.
16339.
They have accepted this is their mistake. Our contention, my lord, this is lack of transparency from the very beginning by this authority.
So why didn't you challenge the appeal court order?
No, my lord, appeal court directed, my lord, to conclude the whole proceedings in a logical manner.
So
Within
why
4.
did you accept it?
My lord, accept so far, my lord, the appeal court.
You did not prefer appeal. Yes or no?
So far, this
appeal order.
mandamus appeal is concerned.
you
No, my
did-
lord, we do not feel
Very
that.
good. So you are stopped from taking
Yes,
that point.
Stop.
Don't re-argue that set
No,
point. We are
sure.
trying to
My
accept.
lord, my
Now come to 98.
98. Then second paragraph, learned Advocate General in his usual fairness says that if the court directs the recruitment process that had been initiated earlier in the 2017 to be carried to its logical conclusion, the same can be done. No fresh recruitment process need to be initiated. That was the mandate of my lord, the Honorable Reed Court. Then my lord, we appreciate such fair stand of state. We are of the view since 1,20,633 aspiring candidate participated in the selection process. And in the written examination, since the OMR seats are intact, the process that was earlier initiated should be carried to a logical conclusion in accordance with the applicable rules and law.
And then an RTI
Very
was made.
Now, thereafter, what happened?
Thereafter, my lord, what happened? My lord, page 101, lordship will find they have published pursuant to the my lord, direction issued by the Honorable Court within 4 months, not within 4 months. They have done it after a considerable period of time. But page 101, my lord, list of 72 candidates.
Who have qualified in the interview.
Who were called for interview subject to verification.
Lordship. My lord, here what happened? My lord, initially, my lord, there is post number of less post. My lord, subsequently anticipated post enhanced. They have categorically stated before the Honorable Read Court the post is 159. My lord, what happened? Instead of 1:5 is the ratio. Instead of calling 795%, they have called only 661%. That particular document is in our hand. That is why, my lord, I am praying, I am beseeching. If lordship kindly allow me, my lord, subsequently the document which I have collected, my lord, I can, my lord, come back along with, my lord, the additional evidence for before this
petition, your lordship.
779.
So was that in the notification the vacancy was
I'm coming. If lordship kindly
page 49?
49, lordship, if we calculate, my lord, at the top, lordship will find, my lord, executive assistant 29. Then, my lord, Nirman Sayak 17. If this total calculation, my lord, it will come.
Where you are getting 20, no? Yes.
Yes, my
Anticipated vacancies.
And my lord, if we come, my lord, 1:5 ratio is to be maintained. My lord,
These
600.
are anticipated vacancies.
Yes, my lord.
What were the actual vacancies?
Now, my lord, is 159.
Where do we find that?
My lord,
So how many was the actual vacancy?
not coming.
Your lordship, in that respect, I'll have to seek instructions, your lordship.
Okay, my lord.
What is Mr. Chakraborty?
Lordship
You
will come.
take up new points every day.
Every day.
On the first day, you said section 4 of the CST.
So the SCST Act violation is there.
Today you come and take a new point
My lord,
when you found that the court was not with you.
No, my
You
lord.
took a new point
No, my lord.
that vacancy is not being
My
maintained.
lord, the document,
And
my
you
lord.
are wanting leave from us to file a
My lord,
supplementary
this is my
evidence.
prayer. We are beseeching, my lord, since this particular
This
document.
is not done, Mr.
No, my lord,
Chakraborty.
true, my lord. But at the same time, this document in our hand, lordship can accept it, can reject my prayer. But how you are beseeching, my lord, they are not doing each and everything in terms of the provision of the law. Transparency is not being maintained. That is why we are raising our voice, my lord. That is why we are raising our voice, my
Mr.
lord.
Bhattacharjee learned senior advocate appearing for the appellants. Is for leave to file a supplementary evidence. Stop. Let's
Procedural lordship, I am
বলতে চাইছি ও সব ম্যাটারেও অ্যাপিল সময় এগুলো কাছাকাছি ছিল একদিনে ছড়া সেটা
I am for the writ petitioner respondent.
There is a delay, my lord, stated in the application that the delay is, my lord,
274 days.
274, but on, my lord, counting, my lord, is something wrong, my lord. It is 238 as per stamp reporter's report.
Good ground lordship for delay.
Good one.
No, no, not good ground. It's not.
which order you are challenging?
Lord, we are challenging the order, my lord, which is 13th of
August,
August 2025.
page 105, 106.
Right. Start from,
So have you served upon all this section 5
yes, my lord.
upon all the private respondents?
সবাই
No, no,
রিসিভ
no.
করেছে? রিসিভ করেছে?
To us affidavit of service
My lord, we have filed.
দেখো তো কতগুলি প্রাইভেট রেসপন্ডেন্ট আছে তো
My lord, some,
private respondents are 7 to 24.
24.
Have
They
you
are,
served upon them?
they are pro forma, my lord.
No,
Whatever
Actually,
you
my lord, yes, my lord,
they were the respondents in the writ petition.
I was along with these persons, my lord, were responded in the writ petition. My
Oh,
lord,
I
the petitioner, my lord, the sole petitioner, this is Sadhan Kumar Mondol.
I am appearing for the Southern Court.
He is appearing for Sadhan Kumar Mondol.
So what order was passed? 13th August order is under challenge.
Yes.
Page 105, Miller. And 106.
You are
I am, my lord, the respondent,
respondent number?
respondent, Imai Mondol, my lord, that is 7. My lord will find from page 102 of the certified copy. Imai Mondol, Narayan Mondol, my lord, 7, 8.
So where is this order of 18th of
Yes, that is, my lord,
9th of January 2018?
that is, my lord will find 97. Page 97. Page 97.
Page 97.
97.
अरे 97 तो
97 the order.
preamble
89, my lord. Page 89. my lord. Kindly. লোকে গন্ডগোল।
ঠিক আছে। Page 97.
Very good.
My lord will find from this, my lord, order, there is no, my lord, order passed for, my lord, demarcation. My lord, no order has been passed for demarcation because of
This
the
was on the basis of a civil code decree.
yes. What happened, my lord?
Partition. Final
There is a partition suit filed by the petitioner. My lord, thereafter, my lord, that partition suit was decreed. The bailiff, my lord, they have in paragraph 7 of their writ petition, my lord, they have agreed that in 1995 we have been given the possession of our share.
by the court bill.
After that, my lord, they have filed this writ petition on the allegation that there is a disturbance in cultivation. My lord will find
Which writ petition?
the writ petition against which this appeal has been prepared.
The earlier writ petition was by him. He's
Yes.
Sadhon.
He filed.
সাধারণ
My lord,
কর্মকর্তা
kindly sees the prayer of the writ petition.
We are not on prayer. Sadhon preferred a writ in 2017.
2017
Court
alleging
said that
alleging-
as he is in a, not alleging, court found that he has obtained a decree.
yes,
Decree has been executed. He has come in possession. As such, police was said, ensured that his possession is not disturbed.
right.
In that writ petition, where you party?
yes.
You are
We are the parties, my lord. I have
very good. Now, how you are aggrieved by
My
this
lord,
order?
aggrieved by the thing is that, my lord, these, my lord, this order,
Hmm.
my lord, kindly sees this line taking this order as, my lord,
Page
sacrosanct, my lord,
106.
this
No.
page 106
Hmm.
top. My lord, I place from the 105 bottom. Since the writ petition was filed in the year 2017 and direction was passed upon the officer in charge local police station so that the petitioner retains the possession of the plot or land which was demarcated by the BLLRO Tehatto Palashpara Nodia by an order dated 9th of January 2018. I direct till the BLLRO Tehatto Palashpara Nodia demarcates in accordance with law no untoward. My lord, there is no question of demarcation. There is no prayer of demarcation. BLLRO was not a party to the proceeding. There is no order of demarcation because ultimately the shares of the parties has already been my lord, adjudicated by a civil court.
Final
And a
decree.
final degree has been passed. Possession has been granted to everybody. And by this, my lord, what I have, my lord, found.
No,
that by
no,
the-
this Sadhon's writ petition, page 89,
Yes.
there was a final decree in a civil suit.
Yes.
Yes, now the decree was executed through bailiff.
Yes.
And bailiff have made over possession to the petitioner.
Yes. After this, in garb of this demarcation, my lord, they are encroaching upon our share. Now
Yes.
they are taking
He's
taking the advantage of this order, my lord. What they are trying to do, my lord, they are in because the
They are
BLLRO
already in possession of the
yes,
decree.
possession has been we have cultivated.
no
No, no, the decree property, which was the property in the decree, which was executed and they were given possession.
My lord, they have stated in
Bailiff.
the
Forget about their prayer. You were a party in the writ petition.
Yes.
page 89 says that from the there is a final decree, and on the basis of the decree, they have been given possession.
Yes. We are not in dispute, my lord, about that position. My lord, let it
You are
be
saying
there.
that how there can be a prayer for further demarcation.
Yes. My lord, that is, my lord, taking the advantage.
Lordship,
We
in
are-
this matter, my lord, the past, we are the possession. They are not possession.
No, you have got possession in terms of a civil court decree.
Civil code, on that basis of civil code degree.
Very good.
Then
Now,
thereafter, my lord,
what
there
further demarcation is required?
further, then thereafter by forcibly occupy this property. For that reason, my lord,
Which property? Which property?
that particular this petitioner, writ petitioner, appellant,
No. If there is a decree has been executed,
and believe
the basis
have
of
already possession. Then thereafter, my lord, by
you got
forcible,
possession.
yes,
So after getting possession, further demarcation issue
question
arises
of
why?
demarcation is not there. Lordship, Lordship, I shall file the object. Huh?
Try to find position possibly.
Lordship, I shall file a affidavit in the opposition on the section 5. 274 days. 274 days delay, Milord, I shall file a opposition, Milord. For that reason, Milord, kindly fix the date.
You are deciding where now?
My lord, in that premises.
In our
Land.
In our land, in our share. My lord, they are.
For this
My lord,
order has been misread. We have cultivated.
We have
Cultivated our land.
Present appeal has been preferred challenging an order dated 13th August 20.
Yeah, affidavit in opposition.
I'm deeply. My lord, has fixed on.
কবে? You opposition you filed. BLRO has issued any notice for
Yes, my lord.
demarcation?
2-3 notice has been issued.
Huh?
They have gone to the place. They are trying to, my lord,
Destroyed our crops.
encroach
crops.
upon our, my lord.
Slept over the matter. What can we do?
Destroyed our crops, my lord.
The appeal you have filed after 258 days.
That is-
How can we
My
help?
lord, actually,
They have
after, my
destroyed
lord,
our crops, my
this order was passed,
I have signed notice.
we, my lord, the actual advocate who was, my lord, in record, my lord, has not.
Destroyed our crops. No. They have destroyed our crops. The grab of demarcation.
Who is for the state?
I'll have for the state also.
You have taken any step, BLRO?
Till now, no step is done. They forcibly
Destroyed our
occupied that's why BLR gone there. After
They
the
forcibly
occupy.
Forcibly occupy.
Forcibly occupied, right to forcibly occupy, there is the BLO gone there. And inquiry made, Lordship. Not to do
No,
anything.
sir, if there is a partition suit decree,
Yes, Lord.
how further demarcation is possible?
They try to
So they are trying to encroach upon the
they are
property.
forcibly. They are
So in the partition suit, they were also parties.
my lord.
So in the some portion of the land must have been given to them also. So they are in possession. You also have not disclosed on the basis of the partition suit which property you are in possession.
We are in position. I'm written in our petition. We are in position in our property. Also, Kali 13.
You are in possession of which portion?
We have
some portion we, my lord,
So that becomes vague, Mr. Dhol.
In our
We could
application.
have granted you a protection. Suppose
my lord,
Sadhon is in possession of the decretal property.
Yes.
You were a party in the partition suit. So the civil court must have passed an order in your favor also.
My favor
And
also.
where is that order?
my lord, order has been annexed.
90.
That on
Page
the
90.
basis of that order, which portion are you occupying?
My lord, let them,
In a
my lord,
dark,
find it,
in
because
a dark.
my lord, my lord, we are not claiming that we have, my lord, something in the Sadhan's property.
No. Now the BLRO will go and will conduct demarcation, which according to you, he cannot conduct.
Yes.
So very good, let him conduct. He is not throwing away from you. We are in ceasing of the matter.
But my lord, what happened, my lord? These
They have
prayers, my
destroyed our
lord,
crops.
were not there.
Mr.
They were
Dhol,
They have destroyed
we
our
cannot
crops.
pass an interim order in the absence of any ground.
They have destroyed our crops. Not to
Also,
do
kindly
anything. Till the
One
they have destroyed our
And
crops.
they are,
One
have
three.
taken, as per my instruction, my lord, there was
Destroyed our
police
crops. Man.
protection for this
Hundred of
BLR, my
police.
lord.
100
Yeah,
of police
my
are
lord,
there.
there
DLRO have
police-
no police
or
protection.
Police protection was
100
given,
police. 100 police.
given for, my lord, that
DLRO have no.
Mr. Dhol, you have not come to us immediately thereafter.
We have
That is
lately
the-
known, na?
If the delay has to be condoned, we cannot shut them out of that.
Nothing.
We can shorten the time. You file your opposition to the section 5. Lekho. Opposition by 10th, reply by 13th. Matter will appear on 16th.
my lord.
Yes. File your opposition by 10th.
Yes, my lord.
And
AO by 10.
Section 5
file টা দাও তো একটু।
না না 10:30 আচ্ছা 10:30
এসব জিনিস আমি করি না।
হ্যাঁ বলছি 10 deeply obliged.
দাঁড়াও, wait, what deeply obliged? Wait, we will pass an order against you. Wait. I direct that deal.
এখানে বলা আছে
আচ্ছা, your BLRO has not taken any step. আসো একটু।
And in this moment, I file a report also on that. I file a report on that. The BLRO, what is the position of the BLRO?
No, pursuant to this
CPR
order, you have taken any steps? No.
No.
My
All
lord,
the notices are annexed.
filed and they have gone for 1 day.
4 days. Now say they have gone on day.
Where notice?
It has been annexed at page, my lord, kindly say page 112
Annexed at 10. Serially আছে।
and
For note.
page 112.
For আছে।
এই নোটিশ পাওয়ার পরও র্যাপিড
112, 130.
Yes, sir.
116,
Section 5.
একটা রিট পিটিশন একটা কেন পেন্ডিং
to the order, page 106. Come to the order. What interim order you are praying? That BLRO shall not conduct any demarcation. This is your prayer. Now see what is the order pass. I direct that till the BLRO demarcates in accordance with law, no untoward incident will take place.
কিন্তু
Anything?
আমাদের
but
পেপার
they are, my lord, taking the steps for demarcation.
Yes,
No, no.
But BLLR was not a party, my lord. There is no prayer for
so what?
demarcation. Anything was not there.
বলছি তুমি?
Nothing was there.
BLR exceptional cases এ আমরা delay করি।
Section 5
বলছিস তুমি তো আমার ডিস্ট্রয় করে দিচ্ছে, ক্রপস নষ্ট করে দিচ্ছে ওরা। সেখানে 100 পুলিশ, কোনো কিছুই হয়নি, পুলিশ নিয়ে যাচ্ছে, নিয়ে গিয়ে বলছে।
Notice was issued 7th of January 2020. Thereafter,
There was
no,
no position.
no further steps have been. All right, we are, when further we are,
Please, also, I filed a report, Lordship.
you file a report
My
on
lord,
the
that
return
is
number.
detailed
Then what steps you have
Yes,
taken?
Lordship. Delete clear a picture. No further step. No further. On that, that is 69.
Stated নামটা লিখে দাও।
ছিল না। My application was not in the file. আচ্ছা। বলে দেবে কি? বলে দেবে? বলে দেবে? Not in the file. Can to show. পুত্র নাম
তো নামটা বল।
তোমার মেমোরি আছে?
যতক্ষণ না সবার
পজিশন আছে কিনা? কিছু পরিচিত কিনা?
ওসিকে বলে দেয় যা খুশি হ্যাঁ
answering your report the behavior has yet so we are recording that pursuant to the order you have not yet demarcated the
Lordship.
huh?
Lordship,
Then
yes.
you we will record that we will
And
hear
I will file a report, Lordship, on that day, demarcation or not.
no demarcation has not been suppose demarcation today if it is made
Made.
it will create further law and order problem.
Yes, 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 Lordship.
Because by way of demarcation, maybe it can be ascertained that Mr. Dhol has encroached upon your property.
Yes, Lordship.
This possession dispute will be there. We are only recording that unless this condonation is allowed, we cannot pass any
Lordship,
interim.
Lordship.
So that the last লিখে দাও, answering our query, Mr. Gul and the advocate appearing for the state respondent. কি এটা you file your opposition by on the reopening.
No, 10th Lordship.
No, 10th, no, we are shortening it because this will create law and order problem.
10th, 13th and 16th.
10th,
10th.
very good, 10th. If you don't file, we are not giving any.
No. I shall positively file.
And in the meantime, if you create any problem, we will look
I
into it.
shall not. I shall not.
Yes.
But he will.
16.
They are trying to execute a decree which has been passed by this civil court, my lord. Trying to execute a decree further.
Don't open your mouth so wide. You have brought the civil court decree. Eh? You were sleeping for 400 days. 300 days we are sleeping. Huh? We are trying to give you protection. You are not serious with your case. Yes.
Then
Item number 11.
We don't.
I appear for the respondent number.
Millard, 2011.
What
we are-
defect is there?
Millard,
Mr. Basu, you are defective. Rather, your appeal is defective.
appeal defective. Canada? Appeal defective. Yeah,
Respondent numbers 13 and 19 do not find place in the cause title of the appeal. Junior টা দেখেনি নাকি? You are for?
I am for the respondent number 1.
Respondent number one.
I was and with Mr. Vishwarup.
You are Jhuntu.
No. Ashit Ghosh.
ঝন্টু তোমার লোক
Mr. Basu is for Jhuntu.
হ্যাঁ
Yes. In name of 13 and 19, who is
13 and 19.
13 and 9? Tetul Haldar and Chitto Haldar. They are
21.
not parties to the
And
proceeding.
Bhavato Saha, 19, 13 is Sri Mohan.
এইটাও advocate
They,
of court কে দেখো।
they have died with passed away, both their wives were.
তাহলে আর how it is defective, you have to take steps. দেখো
In the order sheet, my lord, the first, my lord, the order page 32.
you see the stamp report as
Yes. No, my lord, the land single judge has. Yes. The respondent number 13 and 19 of the implement order does not find place in the constitutional order. And an advocate may be requested to take. কোথায় লেখা আছে?
yes
ওটা না হয়।
কত নম্বর
মারা গেছে এটা
11
কোথায় আছে? My lord, it has been brought to the notice by the learned advocate for the respondent number 7 to 33 in the page number 33 of your lordship's brief that the respondent number 13 and 19 have already expired. Petitioner is granted leave to mask the name of the said respondents.
Who?
Petitioner. Petitioner is directed, that is the order, my lord, order under appeal. Page 30.
When they have expired, you were appearing for them.
No, my lord,
13 and
13 and
19.
19, my lord, this was brought to the notice by the learned advocate.
No, we are one.
My-
They have expired.
They have expired.
So were they your clients?
Yes.
They were your clients.
Now, my lord,
When
the
did
deed was
they
filed,
expire?
my lord, the date of death, my lord, not known to us, my lord, but when the matter was taken up for consideration, we the filed, my lord, before that I am told. But I cannot provide, my lord, the
So
exact.
then
date of-
you ought to have deleted their names from the coster.
My lord, the
Or you
order-
have to bring
order-
their, or you have to bring in their heirs on record.
my lord, the honorable single judge says that it has been brought to the notice by the learned advocate for the respondent that the respondent number 13 and 19 have already expired. Petitioner is granted leave to mask.
the stamp report subject to correction, apparently the stay application that has been served on us contains 25 appellants.
Hmm.
13
And
20
19 has expired.
he is not a party here. 13 and 19, 13 in the writ petition. Please come to the writ petition.
Not 13 in the report, 13 in the memo of appeal.
In the writ petition, 13 Sri Mohan and 19 Sri Bhavato Saha were deleted from the array of parties.
Were
Because-
deleted.
Deleted means they were asked, we were requested to mask their names.
Yes, so 13.
13 and 19 in the writ petition, respondents 13 and 19. Please come to page 46, 47 of the
Mohan
appeal
and
papers.
Bhavatos.
Yes. Now, Mohan and Bhavatos apparently are not parties here.
Then stamp reporter কি হলো? এখানে বলতে name of receipt of the impugned order. No, it is reported 13 and 19 of the
Impugned order.
Yes.
13 and 19 of it.
They have expired.
Yes.
That is why the names were
names were deleted.
Yes.
That's why they have not been made parties.
Yes, rightly not being made parties.
Hmm.
Rightly not being made parties
Right.
because they have been masked.
Rightly, we have understood. You're the one confusing us. Sit down.
We are there only for
Only to confuse us.
confuse them, only to assist.
Ek minute.
Yes,
Yes. My lord, this order under appeal, my lord, that is page, it starts from, my lord, 32. Mr. Bhattacharya's client, my lord,
you have that 13 and 19 you have again included here or it is
No.
missing?
no,
No.
Not filed.
No.
You all right. Come page 100 and
Page Millard, 143 is the suit filed by my client Millard in the year 2011. Millard, the vendors, Millard in the particular heart at Shantipur Millard seeking injunction against Mr. Bhattacharya's client. 143.
yes.
Now Millard, this it's 44, 40,
And effective order is 46.
and effective order is 46. That both the parties are directed to maintain status quo till 12/9/2011. 156 Millard is the it starts from Millard 150. 150 today is fixed for hearing injunction. Both parties file Hajira, but none appeared on repeated calls. On
Last
but
two days.
on last 2 days, also this happened. From such behavior, it is evident that the parties are not willing to do hearing.
So
It is,
injunction petition dismissed.
yes. So, Millard, they filed a counterclaim, Millard, seeking permanent injunction and declaration. That is Mr. Bhattacharya's client, Millard, in the court
Your
below,
suit.
in my suit. Counterclaim and injunction. Now, Millard, both the petitions were dismissed. 156.
No, 150.
Five.
150 which you showed us, that is your injunction petition.
No, I'm sorry, Millard. May I repeat, Millard? 150 today is fixed for hearing injunction. Both parties file Hajiras, but none appeared on repeated calls on but 2 days. And 148 will satisfy your lordship's query. That is Millard 26/9/13 order. Today is fixed for hearing injunction matters. Both parties file in Hajiras. That defendant prays for this on the ground that both the parties for injunction should be heard together.
Where you are reading?
Page 148, your lordship's query I have to answer. 148, my lord, that your lordship said one injunction. I said the injunction applications, one filed by my client, the other filed by Mr. Bhattacharya's client in the counterclaim. Both the injunctions, my lord, should be heard together. That was the prayer made before the court below.
Wait.
Page 148.
Both-
Today is fixed for hearing in the injunction matter. Both parties file Hajira 148. Order dated 26/9/13.
Then what happened?
Now, Millard, 150 Millard, I have shown Millard that both the injunctions were taken up for consideration, but Millard, the parties were not represented. Accordingly, Millard, the fate is inevitable, so it is rejected injunction petition.
Both
Both
injunction
will not
Millard,
file.
it appears both.
No, today is fine for hearing injunction petition.
People know injunction.
Petition is rejected.
Yes.
Anyway, what happened there?
Now, Millard, 156. It starts from 145, 55. Ultimately, Millard, my lord's got it, Millard. Yes. Learned advocate for the defendant submits that as per sanction plan, the construction of the suit premises can be made without evicting the plaintiff. The defendant has obtained sanction and has renewed the same by spending huge money, and the sanction plan is valid up to May 2017. If the defendant cannot construct without this period, he will suffer a great financial loss. The defendant does not intend to evict the plaintiff without due process of law. He only wants to construct a multi-story building, reinstating the plaintiff where the plaintiffs can smoothly run their business. So, Millard, this is the petition which filed by Mr. Bhattacharya's client. He intends to use the first and second floor for the purpose of his unemployed sons. The present market has
tin shed which has become damaged and perforated due to normal wear and tear. He intends to remove the damaged tin shed by concrete roof. So he prays for injunction order to restrain the plaintiffs from obstructing the defendant in construction. Learned advocate for plaintiff submits that it is not possible to accommodate the plaintiffs when the construction work is going on. One engineer on behalf of the defendant appeared on the dock and stated that as per the sanction plan, the scheduled premises can be divided into 2 hubs and construction can be completed within 90 days of each hub. One of the plaintiffs appeared on dock and stated that there are a huge number of businessmen in the scheduled premises and it is not possible to accommodate the persons of one hub to the other at the time of each site construction. On having heard considered, on perusal, I am of the view that in this area of modernization, everyone should approach towards well-being. It is true that shops with concrete roof can conduct business in a better manner than shops with tin shed. From the sanction plan, it is seen that separate toilets for ladies and gents will also be constructed, which will help in sanitation and hygiene. It is true that when construction will go on, the plaintiff will face the same difficulties, but the proper cooperation with the defendant, they will be benefited by getting concrete shops in spite of their present tin shops. Therefore, I am inclined to allow the injunction petition of the defendant as it will not have irreparable loss and injury to the plaintiffs. That the injunction petition of the defendant is considered and allowed on contest without cause. The scheduled premises will be divided into 2 hubs and construction will be started over the 1 hub at a time. The plaintiffs occupying over first hub will be accommodated by the defendant and the other plaintiffs. On the second hub during the construction period of the first hub and vice versa. The construction of each hub will start and be completed within 90 days from the date of commencement of the construction. After reinstating the plaintiffs of first hub, the construction of second hub will start after 15 days of such reinstatement. The first construction will commence after 15 days from the date of this order. The defendant is unable to complete the whole construction within the state. If the defendant is unable to complete the whole construction in a stipulated period, he will have to pay compensation to the plaintiffs. The plaintiffs are restrained to obstruct the defendant in construction of the scheduled premises till the disposal of the suit or until further order, which is earlier. The injunction application is thus disposed of. Then, my lord, ultimately miscellaneous appeal was preferred. The appeal court had modified, my lord, this order, which also, my lord, this is, my lord, unfortunately, this could not become a part of record.
Now, thereafter, the review.
Thereafter, my lord, we prefer a civil revision application being agreed by and dissatisfied with the
Now,
order. Now, my lord,
Page 157, who filed the review? Who again filed review of this
One.
order? 157?
157 review document. Yes, this is filed by my client.
So you were agreed by the order passed by the first
No,
appellate?
I am aggrieved by
the order passed on page 81. Page 81.
Justice Banerjee, my lord, as his lordship then was, my lord. I prefer a revision, review of the order passed by Justice Banerjee. Revision, affirming the order, my lord, passed by the 81, my lord, kindly sees.
Challenging that order of the
Order passed in miscellaneous appeal.
No. Challenging this order at page 156.
No,
Of Civil Judge Junior
156
Division,
order,
you
yes.
filed a misappeal.
Misappeal,
Before
my
the
lord.
ADJ.
Yes, I was also not satisfied with that order.
Very
And
good.
against
Then what
this,
you were?
I
Against
filed
that you filed revision.
Yes, that CO was disposed of or not interfered by page 81.
So you filed a review petition.
Review petition and my lord, the 57, my lord, that is the order which is pending.
Is 157. Very good. Now what?
Now, my lord, what happened? My lord, 2012, my lord, a plan was sanctioned by the municipality. 2017, it was renewed after 5 years. 2015, it was renewed. Then 2017, my lord, revalidated. 3 dates. 2012, the sanctioned building plan. 2015, it was renewed. 2017, it was revalidated.
That is their plan.
That is their plan. Now, my lord, and my lord, this was done, my lord, 2012 to 2015, all, my lord, during the period of injunction, my lord, and my lord, this was known to the municipality that this was done. Be that as it may, Ultimately, in 2024, my lord, the Board of Councillors, my lord, had taken a decision, thereby, my lord, disapproving such revalidation under renewal.
Yes.
Now, my lord,
So refusing revalidation.
yes,
Revalidation was in 2017.
yes, further, my lord, this was,
But the
yes,
revalidation
by,
was
my lord,
refused in 2022.
22.
Then what happened?
Then, my lord, then they kindly 132. Sorry, my lord. I'm sorry, my lord. I stand corrected. 110. 20.
These you can read.
20 cannot.
Neither we can read. You are, he doesn't, he should make a typed copy of this. What is written here? I don't know. Who is Oshit Ghosh?
Oshit Ghosh.
So to Oshit Ghosh, hereby requested to deposit requisite renewal fees. What you are saying? You say, subject to what?
106, 106, my lord. 100
So you told 110.
110 and 100. Since your lordship is on page 107, your lordship was beholding 107.
No, you are showing us 110.
Yeah.
That is the 20.
110, my lord, because I stated, my lord, 2012 plan was sanctioned, 2015 it was renewed, 2017 it was revalidated, 2022 again revalidated.
Then from 2nd of July 2024 at page 110, just may not kindly see fourth line, 3rd May 24 to 2nd May 26, it was once again revalidated.
2nd July?
3rd May 24 to 2nd May 2026.
Millard, possibly Mr. Bhattacharya has jumped one page, Millard. I was on Millard 2022.
Wait,
I was in the year 2022.
22, you said Board of Councillors has refused revalidation. Where is that page?
Page 106, subject to correction. Millard, I am extremely sorry. I tender apology, Millard.
Hence the prayer for it is renewal.
Building plan after expiry of this date, 2nd May 2022, is not permissible in law and the same is refused. And this municipality has nothing to do in the matter. As per existing
Law made in
yes, by in this behalf.
Then what
On this. Then, Millard, 2024, that is, Millard, page 110.
110. Better copy is page 77. I'm grateful to Mr. Gupta, Milord. Page 77.
No. 77.
Yes, 77, Millard. It says, Millard, addressed to Mr. Bhattacharya's client, renewal of commercial building plan such and such in respect of the premises number such and such. He is hereby informed that as per his prayer being application number such and such, and as per the report of retained lawyer of this municipality on dated such and considered his prayer and decided to renew the aforesaid building plan for the said period of such and such years with effect from against the prediction of the Board of Councillors of this municipality at this meeting held on dated such and such against provided under section 211 of the West Bengal Municipal Act subject to payment of requisite renewal fee. He is hereby requested to deposit the requisite renewal fee in this regard within 7 days from the date of receipt of the letter. Otherwise, it will be treated as cancelled. Millard 77 and 106. 106, which
yes,
106, Millard, this was the, if your lordships kindly take pain to turn the top portion of the at the top, Millard, the 106, your lordship will be pleased to find that the office of the Board of Councillor, the letterhead clearly suggests, it apparent, not suggest, apparent that this was a decision taken by Millard office of the Board of Councillor, the letterhead suggests. And Mr. Bhattacharjee, my learned esteemed friend, my lord, has drawn my lord's attention to page 77, which is the subsequent order. My lord, in complete disregard to the disregard so far as the 106, my lord, it says that it has been rejected, and this was signed by the chairman only.
Earlier order was also of the chair.
Earlier also by the Board of Councillors,
No,
the
same,
letterhead.
same
Same
letterhead.
Same letterhead.
Same
but
Subroto Ghosh.
Same Subroto Ghosh, but the office of the Board of Councillor, that is the letterhead.
That is
it
also here, page
Yes,
77.
it
office of
is
the-
hereby, and here my lord, that is the office of, now the chairman has said, the same person within 2 years, my lord, that is a clear somersault. And my lord,
He has challenged it.
yeah, now my lord, now I question this order before
Page
we
111.
the order, the
Ultimately,
operative.
that was relegated to the authority.
Bhattacharjee, my lord, at least shows some decency, because I've learned,
111.
although he's a junior, but I've learned many things from him.
111 you
100, yes.
Hmm.
Your lord, may I take my lord's kind attention to page 100 Oh, 111. 11 তো? 14, হ্যাঁ, 11. Yes.
Yes.
Yes. May I read for my lords?
Yes, read.
It's the operative part, it starts from my lord, page 114.
Page
114, 114. Learned State Council submits that pursuant to the direction of a coordinate bench, April 17, 2023, April 17, 2023, passed in CO number such and such at page 133 to the writ petition, the local police authority had taken steps. The Learned State Council, Police Authority taken, Learned State Council has filed a report dated August 1, 2024, prepared under the seal and signature of the officer in charge, Shantipur Police Station. The same is taken on record. Referring to paragraph 13, 15, and 17 of the said order of the coordinate bench dated April 17, 2023, Learned Council for the state submits that to give effect to an order dated November 10, 2016, the police authority acted in terms of the said order of the coordinate bench. The Learned State Council further refers to an order dated February 2021-24, passed in CPN number such and such, appearing at page number 46 to the report of the police, and submits that in view of the said content proceeding, the police authority had taken steps. After considering the rival condition of the parties and upon perusal of the materials on record, at the outset, it appears to this court that the order of the civil code was dated November 10, 2016, and to give effect thereto in terms of the coordinate bench order dated April 17, 2023, the police authority became active. It is pertinent to note that the civil court order was passed on November 10, 2016, whereas the sanction was rejected by the municipality on August 30, 2022. The moment the sanction was rejected by the municipality, automatically the order of the jurisdictional civil court dated November 10, 2016 lost its force. The subsequent decision of the municipality dated July 2, 2024, by which the sanction of the building plan was approved, would have no bearing or relevance in so far as the said order of civil code dated November 10, 2016 is concerned. The law is well stated that occupiers of the premises cannot be evicted without the established procedure of law. The representation of the petitioners, as referred to above, seeking cancellation of the sanctioned building plan is pending before the municipality. In view of the order, the respondent number 4, upon issuing a prior hearing notice of at least 7 days to the petitioner, and the respondent number 7, after granting them an opportunity of hearing, shall dispose of the said representation of petitioner.
Now the court relegated it.
Yes, relegated it, ultimately rejection.
And said that respondent shall not take any coercive steps.
Yes,
Then
and
what?
Millard, even during the pendency of this during this order,
was
Millard, the police authority intervened, and Millard, they partly demolished our structure. We filed a contempt application. Parties in the proceeding were directed to exchange their affidavits.
Against this Justice Aniruddha Roy's order.
Yes.
Then-
But ultimately, the municipality had approved the sanction plan, which is a subject matter of challenge before the writ court. Now, Millard,
Another writ petition was filed.
Yes.
Where is
It
that
is pending.
order?
No, there is no order. The
No.
order made by the municipal authorities, I might be indecent, but please see 131.
Let him finish. Yes.
Now, Millard, so far as the sanction
So when is the decision taken pursuant to this page 111?
131.
Page 131. What was the decision taken?
Decision, my lord, the ultimately, my lord, yes.
Refused.
Yes. And my lord, ultimately, my lord, the municipality sticks to their, its earlier stand, my lord, that was taken, my lord.
Validated.
Yes.
The
That was, yes, ultimately.
And it is continuing since to up to 26. It is
Right,
in-
right. So, my lord, they affirm their,
Now against this order, you preferred REET.
yes.
Now what did the
Now,
REET
my lord, thereafter, my lord, what happened? My lord, in the meantime, after Justice Banerjee's order was passed, my lord, they filed an application for judicial. This was
Justice Banerjee's
Justice
order?
Banerjee, the CO. That, they have filed an application, yes. Now, my lord, this was also filed, and revision application was filed before your lordship's court. Honorable Justice Shane was pleased to pass an order directing the implementation. Ultimately, a contempt was filed before Justice Shane for non-implementation of the order.
Justice Sen simply did not interfere.
Contempt, no. Justice Shane Millard directed that the order passed by the court below has to be implemented. A direction was passed upon the police authority.
No, page 81 is Justice Sen's order. Court just no, this is Justice Sanjeev Banerjee's order. Page
81 is Justice Banerjee's order. Another order was passed by Justice Partho Sarathy Sen.
Where is that order?
Page 83 onwards.
This is against which order you came?
This is against the order, not this is they came before the Honorable Justice Shane because they filed an application for policial under section 154(1) of the Code of Civil Procedure seeking implementation of the order passed by the learned appellate court, first appellate court, that is the miscellaneous appeal. Now, my lord, the page 80 is the order which your lordship is asking. This order was questioned before Justice Shane.
Justice Sen said?
Justice Shane said in page 86, paragraph 14, in considered view of this court, the approach of the learned trial court is not justified, especially when the defendant revisionist had made a complaint stating inter alia that account of unholy alliance between the plaintiff and the police authority is unable to make construction. Considering the entire scenario, as discussed herein above, this court, while disposing of the instant revisional application, such and such, 86, officer in charge, Shantipur police station, to ensure that the order number 90.
We are not being able to understand what protection you are wanting from us.
After
show us the order of the single judge.
32.
Page 32.
Yes, single judge. ECPN টা কোথায়? ECPN টা আমরা করেছি। ECPN টা আমরা করেছি। অর্ডারটা বার করে পার্থ সারথী আমাকে বার করে কন্ট্যাক্ট সেটা থেকে 107 আর এটা করেছে অনিরুদ্ধ। হ্যাঁ, অনিরুদ্ধ রায় একদম। এটা অনিরুদ্ধ রায়।
Yes. What is the wrong in this order?
Wrong in this order is, my lord, that after the order was passed by Justice Shane, 86, my lord, a contempt application was filed before Justice Shane. Because the
Justice Sen, this page 83, this revisional application was preferred against which order?
Page 80. Against the order, page 80, where the police assistance was refused. Page 80 was the order which is the sequel to an application filed under section 1551 of the Code of Civil Procedure seeking police assistance. This was rejected, against which Millard CO was filed. Page 86 is the operative order, where Justice Shane Millard found that the approach Millard had taken as taken by the learned court below was not correct.
Just a moment. So against this order of 20th June 2023, page 80,
Yes,
Mr. Bhattacharya came up in civil revision.
correct.
No, this order is 20th June 23. Civil revision order at page
Civil
80,
revision.
which you are page 83, which you are showing is prior thereto. That is of
Justice Millard-
17th of April 20.
Millard, page 80, which your lordship has just now sent, Millard,
Uh.
this order was questioned by Mr. Bhattacharya's client.
Where is that order? Page 80 order.
Kindly
this is
take
not
the
right.
trouble. Kindly
The
come
page-
to page
let you,
Millard,
let you,
Justice Shane, just a minute.
83.
this
Justice
page 80
83,
order, 83 order is 17th April 23.
Please read.
subsequent to the order of Justice Shane, Millard. I'm sorry, that was my mistake. 83 is the order. Millard, kindly sees Justice Shane.
83, 83 is the order passed by the.
Justice Shane. This
after
is Millard.
that page 80 was passed.
Yes, yes, Millard. That is yes, that is true, Millard. I stand corrected, Millard.
So now what happened? They have
Now, Millard, what happened? They filed a contempt application for non-implementation of the order dated 17th April 2023
which portion non-implementation?
because the police did not render assistance.
To ensure that the order of 10th November is duly complied with.
Now, Millard, kindly sees then 167.
So on the basis of this direction, they went and sought for police assistance. Now police assistance order, page 80, OC is directed to submit a report as per High Court order. In the meantime, contempt.
Contempt, Millard, is at page 177, 167, filed by Mr. Bhattacharya's client. Contempt is for the implementation, non-implementation, alleging violation of Justice Shane's order.
Then what happened?
Then, Millard, Justice Shane says that
170?
so 167.
Yes.
The court says, Justice Shane says, the photocopy of the Advocate Commissioner report filed on behalf of the petitioner from the materials as placed before this court today, it does not transfer to the court that the present petitioner has at all started any construction. In view of such, I am not inclined to issue notice contempt against the alleged contemners at present. Let the matter be listed on June 24, 2024 under the same heading. Now, Millard, so Millard, this contempt is pending. And thereafter, the order impugned, page 32, which I have praised before your lordship, Millard, Mr. Bhattacharya's client has filed this foolish inaction to implement the same order. They are, এক মিনিট এটাকে দেখিয়ে দিই।
Court has proceeded on the basis that show us any order that the order of 10th November has been done away with. That is the observation. Page 33.
Right.
Be that as it may, so far as the issue relating to sanction plan is concerned, till date the sanction plan has been approved by municipality.
No doubt of it.
There is no direction stalling such construction.
Right.
Now, in view thereof, the
1 month time, Millard, the penultimate paragraph, Millard, I Millard tried to persuade your lordship's conscience that this 1 month time, this is not within my domain. I question, Millard, the propriety of the sanction building plan. The contempt, Millard, for alleging violation of Justice Shane's order dated April 17, 2023, that has not been entertained. Because there is a specific observation I have shown.
But your order against cancellation of that has been turned down.
The order, Millard, the ultimately they turned down.
Petition page 30.
Pending. Millard, it is not within my domain to get it heard, Millard, within
No,
the time.
the cancellation order was turned down by the municipality on
After a sequel to Justice Rai's order, Millard. 9 September.
যেটা টার্ন ডাউন করলো ক্যান্সেলেশন
9 September.
পেজ
136. Free one, sorry. 131, Millard. It starts from the Board of Councillor after Justice Rai's order. A detailed order has been passed affirming its earlier stand.
Now this order was challenged by you, page 32.
No. Page 32 is a writ petition filed by Mr. Bhattacharya's client
For
seeking
implementation of that order.
for implementation of Millard the Justice Chen's order. Why? I tell your lordship, my understanding may be completely wrong. Kindly take Spain Millard to turn page Millard 92.
Yeah,
Page 92. Right. Page 92 is the representation dated 28 March 2025, which finds place in the order passed by the Honorable Single Judge Order Impugned.
No, 17 June.
Page 92. Page 92.
Considering the intention discussed above, court while disposing of the revision directs the OC to ensure that the order dated and passed by the civil judge is duly complied with, failing which a contempt proceeding will be drawn up.
Court Madras SP Nobia to see the 17th April.
মানে ওইটা ইমপ্লিমেন্ট করার জন্য বললো 10/11/2016 সিভিল জাজের অর্ডার সিভিল জাজের
And then also said, in pursuant to the order passed by the under civil court, ultimately affirmed by the Honorable High Court, Calcutta, it is pertinent to mention that till date, no order of stay in regard to the said construction of the market. That is the ultimately Millard, the order dated 17th April 2023, which affirmed Millard the civil court's order, that has they sought to implement this order. Now,
sought to implement contempt preferred.
Contempt preferred, contempt court did not. Then Millard police in action. The police in action filed by Mr. Bhattacharya's client Millard, based on the grievance Millard reflected from the represented page 92, dated Millard 28 March 2025. This order in essence Millard sends a clear signal that the executives are not, law enforcement agencies are not implementing the order.
Yes. Now court has given you 30 days.
30 days time Millard today on the day.
You challenge the order of rejection of cancellation.
Right, page 127.
Yes, 120.
127, that is Millard, the writ petition. Leave was granted by the Honorable Single Judge on 26/9/2024. It is still pending. Right?
Item number 53.
Today it is item number 53 before code number 3.
But this is a contempt order, page
No,
125.
page 127. 127.
127 is a back sheet.
Is a back sheet, Millard. I got the leave, Millard, and the case status, Millard.
When did you get the leave?
Page
That was
128. And it
that
is
was in
today's
September 24.
24. Till it is pending, awaiting disposal. And Millard, page item number 53 today before Justice Kant.
So why didn't you tell that to this court?
Millard, we mentioned the matter twice for upgradation.
This order was passed on 28th of April 25.
We filed this writ petition September 2024.
After 5 months. What were you doing? 28th April was the order passed by the court that bring within 30 days the stay order.
Millard,
you slept over that. 28th April 25 was the order passed by the single judge that I am giving 30 days time, do whatever is possible. This was the order in that time that if they do not bring any stay order, they can, police will. So that order was April 25. You filed your writ petition in September 25.
No. 24. 26.
Yes, what do you say, Mr. Bhattacharya?
No. My case only is Millard implementation of the Honorable High Court's order. He has said everything apart from saying that from the two orders passed in two civil revisional applications, one Millard in 2017, the other in 2022, he has filed two review applications. two independent review applications.
Mr. Bhattacharya, we are not on that. Please come to page 33. We are only on the short issue, last paragraph. In view of the above factual scenario, respondent 7 are granted 30 days time to produce any order, debarring the petitioner from proceeding with the construction as due.
Any order before the superintendent of police, Ranaghat Police District. Why? Because a coordinate bench, if your lordship kindly take the trouble to straightway come to page 86. Kindly sees paragraph 15. 15. Considering the entire scenario as discussed here and above, this court, while disposing of the instant divisional application, directs the officer in charge, Shantipur Police Station, to ensure that the order number such and such dated 10/11/16 as passed by learned civil judge Junior Division, Second Court, Ranaghat, in title suit number such and such is duly complied with. Failing which, a contempt proceeding will be drawn against the officer in charge of Shantipur Police Station. From this, this order is dated 17th of April 2023. From this, an independent review has been taken out by my learned friend's client. And apart from that, from the order made by a coordinate bench, please see page 81. From this order also, an independent review after 8 years has been taken out. Only purpose is to prevent me from working on the basis of the sanctioned building plan. Today I have a sanction up to 2026. What the Honorable Single Judge wanted is, in the event they can get any appropriate order from any forum, requesting the superintendent not to extend their protection to me, then it's all right. Failing which,
that extension, superintendent was directed to extend
cooperation.
Cooperation. Where is that order?
Page 33.
Page 80, the order of the coordinate bench in the revisional application. Order dated 17/4/23.
Yes.
17/4/23. Officer in charge, Shantipur Police Station.
Directed.
Yes.
But this order at page 33 says that produce any order from SP. How will the SP?
To the SP. To the SP.
Page 87, paragraph 16.
Yes, I'm grateful to my learned.
Paragraph 16 is the direction on SP.
Yeah, I'm sorry. Yes, I'm grateful to my learned friend.
165.
After page paragraph 15, I'm grateful to my learned friend, Mr. Bandopadhyay. This court further directs superintendent of police to see that this order is being duly complied with by the officer in charge, Shantipur. So, what the Honorable Single Judge by the order under appeal, 33, wanted is, in view of the efforts of the respondent number 7 to 33.
Implementation of that order. But the issue is cancellation turned down. Cancellation turned down order is challenged by a writ petition in September 2024.
And
the
despite
court
the
said
matter, despite
now, if the court cannot take up the matter, why they will suffer?
At the same time, what we have, correctly, little bit, that I know, pendency of a writ petition does not operate as a stay.
Absolutely right. Absolutely right.
Pendency of a writ petition, if today, they are admittedly
ওরা শুধু টাইম নিয়ে যাচ্ছে সেগুলো অর্ডারে লেখা আছে অ্যাপিয়ার করছে না টাইম নিয়ে যাচ্ছে ইচ্ছা করে পেটেন্সি is not represented. Review that.
This is the order of in the review, on the 6th of May.
They are only taking time.
এই অর্ডারটা তো এই মামলাটা যখন হয়েছে এখানে সুপারিনটেন্ডেন্ট কে পেজ 87 এ যেটা বলে দিল, এসপি কে বললো তুমি প্রসিড করো। হ্যাঁ,
And from this, Milord, they carry a review, they take adjournments, just to cite pendency. Milord, kindly, Milord, pardon me for saying this.
Review from page.
Review from two orders. One is page 83, the other is page 81. Two independent reviews.
Both reviews are pending.
One, Milord, after 8 years, one after 2 years. The only purpose is, Milord, please see the last order, 6th of May.
now what is the problem? If you construct the building, they will be accommodated in the
100%.
That's why.
I cannot say that if they, because they are,
persons who are before us.
yes,
They are how many persons?
They are the market.
130.
They are
but the petitioners before 25 are appellant.
25. So these 25 persons are getting their stall in the new building.
Yes, I do.
Yes.
Yes.
Milord, they have commenced construction, they did not make any single endeavor. So the approach of empathy, Milord, which is made from the bar, Milord, is absolutely, Milord, stands far away from the ground reality.
No,
I filed a contempt. I filed a contempt before Justice Ray. I gave photographs how police entered into the premises and how police.
They are stalling the endeavor.
It is not a question of stalling someone.
Sorry?
They implemented the law.
No, Mr. Basu, the problem has to be solved. You are 25 before us. We will ensure, they will undertake before us that your shop owners will be given appropriate space in the new building.
Yes. And
Otherwise, this becomes
Milord,
an
this-
unending litigation.
Milord, may I come back with a concrete proposal so as to, Milord, explore the possibility of domestic deliberation between the parties? I will come with
There will be some rotten mangoes.
between these parties.
No, I will not deliver. I am not there.
No,
the
Basu,
client.
suppose who are in fact espousing the cause of all the shop owners, who have made your best effort to stall the construction. This sanction plan will expire in 2026.
Yes.
You are 26
No.
before us.
Milord,
We will record in our order that they will be giving
Milord,
alternative space.
but when the construction will commence, Milord,
They will file an undertaking.
Milord, they will evict us from the present location.
Actually, otherwise, how will the construction?
Then we will no income, Milord, no earnings.
Which is
Then how do you
Milord,
want
the
to solve the
original-
problem? Tell us. Then this will go on for 100 years.
This cannot.
Then
This cannot. So may I come back day after tomorrow in the morning at 10:30 with a proposal, Milord, and which Milord, which
Mr. Basu,
no,
after
because
arguing for
Milord, your lordships have disclosed your lordship's mind, Milord, just now, and Milord, I could not anticipate.
No. First of all, at the inception, what my brother was saying, this 30 days time which you are arguing, this has been pending for so many years. This is high time. They cannot say that I will not leave my place unless you construct and you put me there.
No,
That is
I said-
exactly the. Read
Yes,
the order of
yes,
the
yes,
civil
yes.
judge.
Now, Milord, the first order.
If you say that no, I will not allow you to make construction.
That is what they are doing.
Milord, I tell your lordship, may I come back day after tomorrow?
25 জন নিয়ে পুরো কাজ।
না
নিজের নাক কেটে পরের যাত্রা ভঙ্গ করা।
প্রতিষ্ঠান আছে বলছে।
Today you are there. What is the cascading effect is there may be 100 persons. 25 has come today. Tomorrow another 25 will come. Next day another 25 will come. And High Court will pass you an interim order just before the vacation. My lord, I will be thrown out of my business. High Court will be swayed to your benefit. So this is high time that you must take a decision.
Yes.
You
I
take
will.
a decision, he will undertake that I will complete the construction within a particular time. Their validity is by 2026. They will complete the construction, say, upon 3 months, and we will ensure that there will be enough shop rooms to accommodate 25 of yours. Finished, writ petition disposed of.
deeply of them.
After writ petition,
আরে 130 বললে কি হবে? এসছি তো 25 জন। এক কথা বলছিস কেন?
the writ petitioner will be personally present. His son today is present. I shall ensure whenever your lord.
Mr. Bhattacharya,
Yes.
Mr. Basu, they are there. They are not aliens to the property. Now everybody has to be a bit
Balance has to be struck.
balances. So today suppose your with the construction with the sanction plan which is there,
Yes.
you please ascertain how many shop rooms will be in part A and how many
Very
shop
well,
rooms
very
will
well.
be part
Which
B.
is- Which is?
Just a moment. If upon calculation of the shop rooms in comes that this 130% will be accommodated, then there is one aspect of the matter. And if there is less than 130, then that is another aspect of the matter. But this way this is an everlasting
Development is being stalled. But at their instance
no,
for 12 years.
this litigation will continue
For another 12 years.
You will tell us on instruction what time you required for construction of part A
বুঝতে পেরেছিস?
and what time you required for construction of part B.
Very well, very well.
And there are how many rooms you bring your plan. There are so many shop rooms. 25% will be accommodated by the time you construct the building, and we will
And in
dispose.
the meantime, Milord, it will be understood that in terms of your lordship's order, whatever construction
We
is
will
being-
be in CC of
Very
the
well,
order.
very
We
well,
are
very
not
good.
disposing it off.
Very well.
We are wanting to solve the problem.
Very, I have no problems.
We have heard.
তবে Thursday?
আসবে না ভাই
ছুটির আগে?
তা ছুটির পরে করুক পাঠাট করে দেখো পাঠাট পর
না, না, ছুটির আগে। ছুটির আগে। না, না, আমাদের construction delay হয়ে যাবে। Day after tomorrow.
Mr. Basu, I don't think problem will be easily solved. You come and let us know whether your 25% are willing to go or not. If they are willing, we dispose it.
Tomorrow, day after tomorrow keeps, I'll come.
10:30
10?
আরে অন্য জায়গায় ওখানে সম্ভব না।
আমি কি করবো? আমার কি করবো? তোমার কাজ আছে বলে আমার কাজ নেই?
সকালবেলাটা করে দে না
এ আবার কি কথা?
It is understood we will not give you so much of time. We have expressed
tell me.
our mind. Please, Mr. Basu.
Sir, I'll not trouble you a lot.
No, Milord, Thursday.
Yes, Thursday.
Very.
Thursday.
Thursday কি? দুটোর সময় না সকাল? সকালবেলা?
সকালে।
আমি নিজেও জানি না।
Milord, 25 vendors have come. So far as the entire number total 130.
They
120.
were never in the picture. They were never in the picture, Mr. Basu. All the writ petition, revision applications, everything, these are the interested persons.
Yes.
We will shorten it. We are leaving other shop rooms open. Let them come. But construction should start. Like we have
Milord, let it be Milord পাঠাট
Pathad.
মুর্শিদাবাদের মধ্যে মানে I have no problems. Pathad, Milord, at the top, everything, Milord, I have no problems. Whatever he says, otherwise he'll say that, Milord, otherwise, nothing much.
No, your sanction is still
26. May 26.
So, Mr. Bhattacharya,
Fine.
will it be possible for you to, within one day, to ascertain that when the construction will be over or not?
Yes.
Either that or we keep it on the reopening.
No, but one day keeps it, Milord. Otherwise, Milord, I will not be able to proceed. They are still, Milord, every day they are, Milord, acting as a spanner in the wheel. No, he is.
Thursday, both of you can come with hopefully some sort of a settlement.
Please sit together and if you can solve the
Mr.
problem,
Gupta.
nothing like that.
ওই তো আছে তো
We have extensively heard Mr. Basu.
Here that your lordship will not know.
চলো
এই দাঁড়াও, জজ সাহেব ওঠেনি এখন।
Who is your other side?
ওগুলো তো ওর ফাইলে চলে গেছে, তোর ফাইল কোথায়? হ্যাঁ, ওই ফাইলটা শুরু হয়ে গেছে।
He was served in WhatsApp. Even he is not engaged by the Minister of Law and Justice also. No one is engaged. Just he was engaged. He was appearing the single bench.
Affidavit of service.
Was
My lord,
engaged
I'm
with single
really
bench.
sorry
That's why he was served.
to take up this time.
Until your lordship knows that no one, until and unless engaged by the Minister of Law and Justice, he cannot appear.
But they are being throwing out, they are being removed, na?
Demolition is taking place.
In the morning, he's only over telephone. He requested me. Mr. Sonajit Ghosh over telephone. He requested me. Not, this is the situation. He was served by
1.85 crores.
My
Outstanding.
lord, that they have not shown any calculation. My lord, the background of the case is these are plots where license fees were fixed based on land value. My lord,
You are license holder of plots of land.
plots at Shialda siding.
And now you have made any construction on that?
No, my lord, these were old sheds since before even 1980s.
So now what is
My lord,
you order was passed on 16th May.
16th.
Then what demolition they are doing? How many plots are there? How many persons are here?
My lord, originally the writ petitioners were numbering about 48, but in this appeal, my lord, there are only 28 who have come forward with this appeal. These were the old British time structures which were there where all the materials which used to come in were stored.
Secured the amount. You secured amount.
My lord, at that point of time, what had happened?
You cannot eat the cake and have the topping
My lord, I'm not denying that I'm not willing to pay. The original writ petitions, the two writ petitions are with regard to the calculation of the amount. What the railways are doing is
They have enhanced it at a higher rate and more frequently than you would like. As a licensor, they are entitled to do it.
Lordship, I'm not denying it. Because, and they stopped taking payment from 2010. My lord, we have...
Because you wanted to pay at a lower rate, Mr. Bose.
My lord, even during the pendency of the writ petition last year, my lord, we wanted to settle the matter and pay them.
You are running any business from there?
Lordship.
How many plots are there?
My lord, at this
point, there are 25 persons.
My lord, at this, these 25 are only operating at that. And this amount which has been shown through a notes of argument, my lord, they have not shown any calculation. Which portion and who is to pay what amount? My lord, as he would, for the first writ petitioner, he doesn't know exactly what his exact amount is.
When it is done, no date, nothing, we don't know.
My lord, it was sent today.
It was.
My lord,
there are cameras noting the date and time the snap was taken.
My lord,
order was passed on 16th May. Today we are on 20th.
Lordship.
When was these photographs taken?
Today.
Well, how will we know?
My lord, I can show you the...
that is your WhatsApp message, sir. Where is the indication that this was taken today?
My lord,
your submission is demolition is going on. Then there has to be a live photograph of
my lord, unfortunately, my lord, most of them do know how to use a smartphone.
I don't know.
But the date and stamp and watermark.
Newspaper. You don't know how to get the date.
Well, that is my fault. That is my fault, not my client's.
How can we help you then?
My lord, let them at least come up with
We
the,
cannot make an unimplement, we cannot pass any order which we cannot implement.
my lord, stay.
Today at 12:30, we will pass an order, don't demolish. They will come and tell us tomorrow that before you pass the order, we have demolished.
My lord, I had prayed for stay of the operation of this order. Impugned order under challenge.
You are also not.
Who appears for rail? Who
Four
appears-
plots have been, the first 4 plots have been broken.
First four.
First 4.
I'm also appearing on behalf of the Union of.
No, who is your senior? Tell us now.
Is it engaged the senior? Sonojit Ghosh is all along is that Sonojit Ghosh also appearing on behalf
No, he has not come. So somebody has to appear, na?
today.
Today somebody has to appear before us. We want to know. You take instruction then whether their demolition work is going on today or not.
I can take instruction if it is keep tomorrow.
We will keep it tomorrow, but we want that if demolition is not going on, you start demolition after we hear the matter. But we cannot pass that order because we do not know what is the present status. This is our difficulty.
What's a video? Live video though. Live video though.
By today I can.
আমাকে দাও ওরে
Who is your senior counsel? Who appears for railways?
Sonojit Ghosh also appears. Souvik Nonji
how
also
will we
appears.
know tomorrow Sonojit Ghosh will again be absent? How will we know?
Souvik Nonji also is there.
I don't know. That is your trouble. Then.
Sonojit Ghosh will appear.
Please take instructions. Whoever appears, at least apprise us
Yes,
of
I
what
will
the
take
situation
instruction
is.
today.
Mr. Bose,
Mr.
wait till
Sonojit Ghosh
tomorrow.
will today instructed me he will not come. He will come tomorrow.
Then let there be a stay only for today. Only for today. Only for today.
Without being satisfied that whether your plot has been touched or not, we cannot stop them from proceeding against the other plot. You yourself have submitted 20.
If there is, my lord, if I may be permitted to pray, even if there is a stay for the operation of the order, then they will have to, or they can stay their hand in the notice.
If we pass an order, it has to be complied with. We will not leave an avenue wherein persons will come and say that after the order was passed, no demolition was done. All demolished in the morning.
My lord,
it was incumbent upon you to be more conscious about the facts and to able protection. We
my
gave
lord, may
you
I be permitted to pray a stay of the operation of this notice, Annexure F, Volume 3, page 521, Volume 3, Lordship.
Sir, you should have also taken instruction that what is presently going on.
Actually, what happened today morning, I have been informed. No one engaged from the Ministry of Law and Justice. Until the Ministry of Law and Justice engage anyone, your lordship can direct any lawyer to engage. Thereafter, instruction may be.
My lord, thankfully, he was my batchmate, so I didn't let him leave.
It doesn't say demolition.
My lord,
says
they will
possession.
take
Taken possession. You will be thrown out.
Lordship, demolition is part of. My lord, railways always adds its own to any kind of order. Only for today. And if it is taken up tomorrow morning,
You deposit the money. We grant you the
but
stay.
my lord, 1 crore 85, but it is not for 28 people. It is for all the plots.
Mr. Bose, we are not being able to understand the matter in the absence of the railways. You show your bona fide.
My lord, if
Put in the
I may
1.85.
suggest, 50,000 per writ
Mr.
petition.
Bose, we are not open to bargaining.
No, my lord, only these writ petitioners who are
How do we
appearing.
know how much each writ petitioner has due?
My
What
lord,
is
we
the
really
against
don't
them?
know because they have not raised any bills. We've been wanting to, my lord, were carrying.
Tomorrow it will be the first matter. 25 you are here. In the meantime, you ascertain whether your 25 plots have been they have done anything or not. Come and tell us tomorrow morning. In the meantime, we are not being able to engage any lawyer at this stage. But you please do not sleep. You instruct your what is going on. We must know the factual backdrop tomorrow morning.
Yes, ma'am. In the meantime, I will.
My lord, the per plot amount this is, I'm not bargaining. Per plot
You
amount
also
as
come
ad hoc
tomorrow.
payment
Come
of
tomorrow with the
50,000 per plot.
calculation
That's
in respect of these 25%. What is the total amount payable?
Yes, ma'am.
License fee. What is the total amount payable?
Yes, ma'am.
Chalo, kalke
my lord, would my learned friend be taking an undertaking that no further demolition be carried out today?
Sir, we cannot pass that order, na? How can we pass that? You are not being able to satisfy us whether your plot has been touched or not. If your plot has not been touched, we are not
My lord,
concerned
10
with the
minutes at 2 p.m. My lord, after recess, because I understand there is an assigned matter.
We have an
Maybe come back at
Come tomorrow. Come tomorrow. In the meantime, you take all instruction. Come back tomorrow. It is a question of taking possession. If possession is taken, no, another person is not being. There is no.
But my writ petition would and my appeal would become infructuous, totally infructuous. কি বলছো?
Yes,
Well, only for today. I'm just praying only for today since I'm coming back tomorrow morning.
Suppose come back tomorrow. Come back tomorrow morning.
My lord, the affidavit of service be kept on record.
We will take it back. Take it. Huh? ওইগুলো ওকে দিয়ে দাও। But tomorrow, if you are not with the instruction, we will proceed. And whatever documents you have, any further documents you gather, make a supplementary affidavit and file it tomorrow with an advance copy to him. ডাকো judgment ডাকো। এগুলো হচ্ছে মনোপলি।
We've allowed your appeal, Mr. Madhuri. But I'll just read two operative paragraphs. Having set aside the impugned order, we are now faced with a rather onerous task of balancing the rights of the parties. ECL has not been in a position to supply coal, which it ought to have supplied to the predecessor of the appellant's herein, due to a change in their policy. We have not been apprised of the price of coal at the material time or even thereafter, nor of the cost of lifting such coal by the appellants, by either of the parties. It could be an empty formality to pass an unenforceable order directing ECL to supply the balance 17,900 metric tons. And then the quantum of compensation would, however, depend upon the peculiar facts of each case, and no straitjacket formula can be evolved. The appellants have suffered distraught pain due to the stonewalled response from an apathetic administration. They have been deprived of their claim for a substantial period of time, which on its own merit is a matter of great suffering. Since it is an admitted position that ECL had acquired the land of Badol in the year 1980 and the litigation had continued for more than 32 years, we are of the view that ends of justice would be met if ECL is directed to pay a lump sum amount of 25 lakhs to the appellants.
My lord, I'm praying for operation of the order.
Payment is to be made within a period of 6 weeks from date.
Praying for operation of this order.
What pray for? Go to the Supreme Court you want.
May I have your lordship's kind leave, my lord. But
But you are praying for stay of operation. Hey, लिखे ना.
You are appearing for ECL, Council for Eastern Conference Limited. ECL is for operation, stay of operation of the judgment. Such prayer is
on, my lord.
We would be coming back at 2:15 because.
Look.
2:15.
My lord.
We are making an endeavor to come back as early as possible.
Let's your lordships kindly grant me leave to make a mentioning, my lord.
Yes. Yes, Mr.
But on the last occasion, I was addressing the court. But I had placed, my lord, the judgment under appeal. I have placed, my lord, portions of the writ petition.
And the backdrop in which the conclusion was adopted.
Yes. Now, my lord, my first point would be that in the backdrop of the case pleaded and the made,
Yes.
my lord, whether, my lord, this kind of an order could have been passed. But I presume for argument's sake that there has been some corruption. I don't agree to that because the word corruption has to be understood first. And then whether there was any corruption or not, that would come later on. But be that as it may, whatever are the findings of the learned judge, assuming them to be correct, but whether, my lord, this direction could have been passed. Now, what is the direction? Please have a look to the about 2 paragraphs of the judgment, my lord, at page.
611.
It starts from 611.
Which volume you are referring to?
My lord, it would be in the 3rd volume.
611 you left us on that day.
611 is the starting page.
Yes.
Please take paragraph 21 at page 624.
Yes.
In such circumstances, I allow the writ petition, the appointment of all 36,000 more or less candidates who were untrained at the time of recruitment in 2016 recruitment process conducted by the board in the post of primary teachers are cancelled for various reasons as have been elaborated above. The reasons will I'll take you one by one later on. But this is the ultimate direction. Please have a look to, my lord, the writ petition now. Where it starts, the relevant portion your lordship would find word at page 36 in the first paper book. Your lordships are aware of the facts by now. The writ petitioners, my lord, are untrained candidates. They are unsuccessful candidates. They are claiming parity with those who have been appointed, those untrained who have been appointed. And therefore, the prayer is that pass a direction or a mandamus to appoint us. Now, please have a look to, my lord. For example, paragraph 11 at page 39, 3 or 4 paragraphs, because I placed it in its entirety. Yes, in its entirety. So on this point, the relevant paragraphs I'll just place.
Yes.
Paragraph 11 says, your petitioner states that on so-and-so date, notices were published for recruitment as assistant teacher in primary schools from TET 2014. The board has appointed non-trained candidates after 2016. Even and intentionally ignored the petitioners by giving excuse of notification dated 9th of April 2015. Thousands of non-trained students were appointed and the petitioners, though similarly placed, very important, petitioners, though similarly placed, were ignored. If it is the stand of the board that no non-trained candidates can be appointed, then all the appointments of non-trained candidates made after March 2016 are bad in law. The relaxation given by NCT, etc., to applicable to all TET 2014 candidates who qualified for examination. Or in other words, Millard, they are claiming parity with those who have been appointed. Yes. But the case made out is, as your lordship would find out from all the paragraphs, that these people have been discriminated, or the petitioners have been discriminated, those who have been appointed. Now please take another paragraph, which is paragraph 20 at page 43.
Yes.
Your petitioner states that your petitioners are praying for equality before law and equal protection of the law. Huge number of non-trained candidates were appointed by the board, and when the petitioners are seeking the same benefit, the board is saying NCT guidelines is against them. The NCT guidelines was there since 2016, and if TET 2014 qualified non-trained candidates can be appointed in 2017, then there should be no bar in appointing the present petitioners.
Yes.
Then para 21. Last sentence in para 21, I don't think the entire paragraph is required, but last sentence, para 21. But here the board has done complete injustice to the petitioners. Now this is the fulcrum of the grievance.
Yes.
Now please have a look to the prayers at page 47. I placed it on the last occasion also. Please have a look to prayer B III at page 47.
Yes.
To direct the authorities to treat the petitioners equally with the non-trained candidates who have been recruited by the board after expiry of relaxation given by MHRD on 9/4/2015. Then Roman 4, to recruit the petitioners by giving them the same benefit by which the other non-trained candidates were recruited by the board by following the rules dated 2nd March 2016 and appointment notification dated 26/9/2016. 5 is to direct the authorities to publish merit list by maintaining full transparency regarding TET 2014, then to protect all documents, etc. No prayer for cancellation of anybody's appointment.
Yes.
Therefore, my lord, on this issue, there are two facets. The first facet is that the petitioners are claiming parity with a category of candidates who have been appointed because they fall under the non-trained category. So parity claim, queer discrimination is the first facet. The second facet is applying for mandamus or praying for a mandamus that we should be appointed. Now, in this background, or in the context of this pleading and the relief sought, whether 36,000, 32,000, whatever, candidates' appointment can be cancelled or not, but in my very respectful submission, it cannot be done. Because reliefs are to be given in terms of the case made out and relief sought.
No, you please place paragraph 22 also.
Very well. Corruption. But I'll come to corruption.
As you are talking out the pleadings, broadly the pleadings was.
Yeah, subject to your lordship's permission, but I would like to address your lordship on each point separately, and I'll place the relevant paragraphs square the point. But when I'll deal with the corruption issue, but I'll definitely come to paragraph.
Yes. On the basis of these pleadings, this order at least could not have
been made. This is the first point. Number one or two decisions on this, then I'll go to the next issue. এই জাজমেন্টগুলো ধর এখানে এসে আমাকে দিয়ে দে এখানে 2010 এক বের কর 2010 এক এসসিসি পেয়েছিস 10 এক এসসিসি 234 তারপর খুঁজ না আস্তে আস্তে গুলিয়ে ফেলবি
If you don't have it, we can use. We can get.
But I have made copies. একটা কপি দে আরেকটা দে না পরেরটা এটা সেলেক্ট করেনি but I'm sorry it's not stitched kindly excuse me but the first judgment on this point is reported in 20 এই পরের জাজমেন্টটা বের করে দেন খুঁজতে সময় লাগবে 2024-2 এসসিসি 570 this is reported in 2010 volume 1 Supreme Court cases page 234 but I'll be relying on paragraphs 29 to 33 24-2 570
yes
29 to 33
yes
the approach of the High Court in granting relief not prayed for cannot be approved by this court. Every petition under Article 226 of the Constitution must contain a relief clause. Whenever the petitioner is entitled to or is claiming more than one relief, he must pray for all the reliefs. Under the provisions of the Code of Civil Procedure, if the plaintiff omits, except with the leave of the court, to sue for any particular relief which he is entitled to get, he will not afterwards be allowed to sue in respect of the portion so omitted or relinquished. Though the provisions of the code are not applicable to the proceedings under Article 226 of the Constitution, The general principles made in the Civil Procedure Code will apply even to writ petitions. It is therefore incumbent on the petitioner to claim all reliefs he seeks from the court. Normally, the court will grant only those reliefs specifically prayed for by the petitioner. Though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even prayed for by the petitioner. In Krishnapriya Ganguly, overlooking the rule relating to grant of admission to postgraduate course in medical college, the High Court, in the exercise of powers under Article 226 of the Constitution, directed the Medical Council to grant provisional admission to the petitioner. This court set aside the order passed by the High Court, observing that in his own petition in the High Court, the respondent had merely prayed for a writ, directing the state or the college to consider his case for admission. Yet the High Court went a step further and straightaway issued a mandamus directing the college to admit him to the MS course, and thus granted a relief to the respondent which he himself never prayed for and could not have prayed for. Again, in Om Prakash versus Ram Kumar, it was held a party cannot be granted a relief which is not claimed if the circumstances of the case are such that granting of such relief would result in serious prejudice to the interested party and deprive him of the valuable rights under the statute. Though a High Court has power to mold relief, this part is very important. Though the High Court has a power to mold reliefs to meet the requirement of each case, that does not mean that the draftsman of a writ petition should not apply his mind to the proper relief which should be asked for and throw the entire burden of it upon the court. Very frequently it is said that the court can mold the relief. But here, Miller, the Supreme Court says that you have to be careful about your drafting. You cannot expect the court to take upon itself the burden of granting the relief. Pray for the relief, make out a case, get the relief.
Yes.
What a pitch.
Next judgment.
But the next judgment is 2024, Volume 2, Supreme Court Cases, page 570, 570.
Whereas?
Only one paragraph, 26. Which is so? আচ্ছা 10-11 বের করে রেখেছিস AIS 61 ক্যালকুলেটর বের করে only one paragraph from this judgment, para 26.
Yes.
I need not place, just note the paragraph number. It's saying the same thing. But the other judgment on this point is 2010, Volume 11, Supreme Court Cases 557. 10-11.
Five,
2010, Volume 11, Supreme Court Cases 557. We had a few paragraphs from this judgment. But at paragraph 2, the Supreme Court framed the issues to be answered. Paragraph 2. In these appeals, 3 substantial questions of law for consideration of this court are involved. They are namely, please take C. Whether the court can grant relief which had not been asked for. Formulating this question, now Supreme Court starts discussing. Please come to paragraph 30.
Yes.
In Projan and Company, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. The court held it is well settled that the decision of a case cannot be based on grounds outside the pleadings of the parties, and it is the case pleaded that has to be found. Without an amendment of the plaint, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate 61 Calcutta Brigade 61 Calcutta with the ACC online. It is well settled that the decision of I'm reading the quoted paragraph 22.
Without an amendment of the plain, court was not entitled.
Yes. Para 31 says a similar view was reiterated by this court in so and so. Observing that a party cannot be granted a relief which is not claimed. Dealing with the same issue, this court in Bharat Amrat Lalmer, this one I have placed. Then para 33, in Fertilizer Corporation, this court held that the High Court ought not to have granted reliefs to the respondents which they had not even prayed for. Para 34, in view of the above, law on the issue can be summarized that the court cannot grant a relief which has not been specifically prayed by the parties. The instant case requires to be examined in the light of the aforesaid legal principle. Therefore, my lord, here also, my lord, I am praying before this court that in view of the pleadings and the case made out, irrespective of whether the prayer has been made or not, whether this prayer could have or this relief could have been granted or not. I assume for argument's sake that the prayer is couched in such a manner that it could have been granted. Even assuming that, my lord, the case which is made out does not call for, my lord, cancellation of appointment of strangers, non-parties. Well, that is an issue I'll take later on separately.
Yes.
But there's an old judgment of our High Court of 1961. Well, it's a single bench judgment, but kindly have a look to it. AIR 1961 Calcutta, page 411. না ওতে লেখাই আছে ওটাও লেখা
Yes, para.
But paragraph 27 of the report.
Yes.
Milord, drawing the principles of Order 7, Rule 7, Milord, the court holds, it is contended that even though a restricted injunction is claimed in prayer H, the court is entitled to grant a decree for injunction in wider terms. There is a prayer for further and other reliefs. Further, Order 7, Rule 7 expressly empowers the court to grant such general or other relief as the court may think just, to the same extent as if it had been asked for. In order, however, that such a relief can be granted, the ground for granting such relief must not be inconsistent with the claimant's claim. This is very important. It is contended by Mr. Chaudhary that the plaintiff's case is that the lease was granted, etc. Therefore, the relief also should not be inconsistent. That's why I said, Milord, assuming, Milord, for argument's sake, that the relief that has been granted could be inferred from the prayers, or the prayers are couched in such a manner that such a relief is contemplated. Even, Milord, assuming this for argument's sake, then also the relief should not be inconsistent with the petitioner's claim.
Yes.
And subject to correction by my learned friends, possibly the writ petitioners are not aggrieved by this order. Possibly they have not preferred an appeal. Possibly subject to correction. এইটা না করে না 2008 চারটা বের কর 8-এর 4
সিলেকশন এর ব্যাপারে কিছু বললো না। Termination to the otherwise procedural to earlier. Yes.
Okay, sir. So regular year wise রাখলে না খুবই ভালো হতো। এটা
Yes. Clearটা হচ্ছে by which recruit the petitioners by same way.
ওইটা হচ্ছে আর্ট স্কিল অ্যাপয়েন্টমেন্টে মানে কোর্টের অ্যাপ্রোচ না corruption
You are the board. You
Yes.
are the board.
Yes.
You are trying to
Justify my action. Justify my actions.
to authenticate the steps you have taken.
Right. Right. Right.
So, in your limited domain, what will be the thrust of your argument?
Well, my basic thrust of the argument.
Writ petition, your selection which you made has been upset, but the loss of job is of the other persons
Right.
who
Right.
are.
Right.
So,
Yeah.
on that basis, what is your argument?
Milord, as the board, Milord, I have undertaken a recruitment drive.
Show us that the recruitment process which you have undertaken has been in consonance with the rules.
Milord, before that, Milord, may I place before your lordship, Milord, judgments which deal with, Milord, what is the approach of the court or what is the scope of judicial review in respect of recruitment drive where thousands and lakhs of people are concerned. Milord, here, Milord, 1,20,000 candidates participated. Appointments given to 49,000 and 42,000.
1,25,000.
20. 1,20,000. Some 1,20,000 odd.
How many were the vacancies?
42,700 and odd.
42,900 odd. Yes. So in a selection process of such a nature,
Such a nature, what is the scope of interference by writ courts? The first judgment on this, amongst other, I won't say the first judgment, is Shodanando Hello's judgment, of 2008 Volume 4 Supreme Court cases 619.
Justice Sirpurkar.
This is, yes. Well, my Lord Justice Chakraborty had the occasion to consider this in the civic volunteers case.
Yes.
Yes, also.
পরে 2017 এসিস অনলাইন ক্যালকাটা 379.
Yes. Six one. Paragraphs?
I'll be relying on a lot of paragraphs. It would start from para 30 because all sorts of allegations were made. That's why. Please note down the paragraph number, around 10 paragraphs, not many of those.
We shall go through it, Mr. Dotto. You can do
very well.
it a short.
Yes, very well. Please take me paragraph 34.
You will be placing paras 34 to?
I'll be placing paragraphs 34, 36,
yes,
37, 41, 49, 52, 56, 58, 60 and 62. About 8-9 paragraphs. But I'll just hurriedly place those. I've only selected only those which
yes.
However, since the courts below referred to the other defects in the selection process, we would take a stock of those findings. It was firstly urged by way of a complaint against these interviews that the dates were changed, and that was done in order to meet the political goals on the part of some leaders. We do not think that this complaint was justified. Firstly, there were no proper pleadings with necessary details before the learned single judge. Secondly, how the postponements affected the selection process is nowhere displayed. And further, which political leaders were responsible for such postponements of the interview dates had also not been pleaded. On the other hand, it was found that the records were found from the records that the postponements were on account of Asian Car Rally, Kali Pujo, Diwali and Eid festivals. If that was so, we do not find any reason to hold against the selection process, and indeed, though we find some murmur in the judgments appeal against, we do not see any definite finding that such postponements affected the selection process. The very fact that there was a huge turnout in the district suggests the hollowness of the claim. We therefore, so one of the allegations was postponement of dates. Now kindly take me, Lord, para 36. We are therefore left with only one major contention regarding the enormousness of the number of candidates interviewed and the possible inability on the part of the interview board to complete the interviews in a proper manner. We would therefore proceed to consider this aspect in details. The basis of the contention regarding this factor made by the writ petitioners was the paucity of time. Based on such factors like the available time, the general requirement for assessing an individual candidate for the post of constable, the number of persons available for holding the interviews, the learned single judge had come to a finding that every board on one day could at the most interview 250 candidates. The division bench also seems to have endorsed the view. We have very carefully examined the contentions raised by the appellant's hearing and also the materials provided by the state through its counter affidavits, as also the plea raised by the officers who actually held the interviews in respect of the 3 districts of so-and-so. But before we go into the exercise of considering the situation in the 3 districts individually, we must consider the benchmark fixed by the learned judge at 250 candidates per day. We are afraid we cannot uphold that finding. The learned single judge as well as the division bench seems to have proceeded more on imagination than reality. Such a benchmark could not have been fixed generally, and only because that benchmark was allegedly breached, the selection could not have been found fault with in a mechanical and mathematical manner, instead of testing the matter on the basis of ground realities for each district on the basis of materials made available by the state. A mechanical approach, in our opinion, could not have been taken by the High Court. So, but this is made on the other aspect. The third is, kindly take me note, paragraph 41. But here, Millard, in our case, the judge, Honorable Court, Millard, proceeds on the basis that aptitude test was not taken. Whether or not it was taken, I'll demonstrate. But assume for argument's sake, it was not taken. Then, Millard, what should be the Millard approach of the court? The question of large number of candidates appearing for selection process again came up before this court in Joginder Singh. A complaint was made in this case that 323 candidates appeared for the test in 2 days, and on that basis a select list was prepared by the Departmental Promotion Committee. The High Court called this selection process as a farce. In our case also almost similar finding, on the ground that fair chance was never given to the candidates to show their worth. The court observed in paragraph 5 as under. On the facts on record, we see no justification for the High Court to have come to this conclusion. The High Court, in exercise of its jurisdiction under Article 226 of the Constitution, is not supposed to act as an appellate authority over the decision of the Departmental Selection Committee. If the committee has been properly constituted, as in this case, and the post is advertised, and the selection process known to law, which is fair to all, is followed, then the High Court could have no jurisdiction to go into a question whether the Departmental Selection Committee conducted the test properly or not, when there is no allegation of malafide or bias against any member of the committee. Merely because there were a large number of candidates who appeared on 2 days cannot ipso facto lead to the conclusion that the process of selection was a farce and fair chance was not given. Normally, experienced persons are appointed as members of the selection committee, and how much time should be spent with a candidate would vary from person to person. Merely because only 2 days were spent in conducting the interviews for the selection of class 4 post cannot lead to the conclusion that the process of selection was not proper.
Yes.
Then, Millard, the next paragraph is paragraph 49. Then kindly take note paragraph number 49.
Yes.
Kindly see paragraph 49.
49, yes.
Where your Lordship recollects, Millard, here one of the allegation is that the persons who had lesser marks in academic qualification has been granted higher marks in vivavoce or interview and aptitude test. 49. Learned single judge in his judgment has observed that as per the report of the amicus, the selected candidates got higher marks in vivavoce ranging between 30 to 41 marks. In our opinion, this has hardly any effect. This is what the Supreme Court is saying. And merely because the selected candidates got higher marks ranging from so and so, that by itself could be no reason to reject the selection. We have extensively referred to the comments made by the learned single judge on the earlier part of the judgment, where the learned judge has in fact recorded his satisfaction for the printed charts and more particularly about their authenticity. The learned judge had also expressed his satisfaction with the procedure adopted. There is hardly any reason given by the learned single judge accepting that the benchmark of 250 candidates have been crossed. But what the Supreme Court says is of no significance becomes the foundation of the judgment under appeal before your lordships. Then, my lord, your lordships may kindly take para 52. The para 52 is dealing with the impossibility with the time factor.
Yes.
Para 52. It is then asserted that in all 5540 candidates appeared between 3rd December to 8th December, and interviews were started at 6:30 a.m. and lasted till 8:30 p.m., giving clean 14 hours to the selection committee. It is pointed out that out of 5540 candidates, 1815 candidates were selected on being eligible, physically fit to appear for viva voce. It is then pointed out that the candidates who were left out of the viva voce due to shortage of time on the date of selection were called on 1910, 9/12/24 and 2004 and 10/12/2004 also. It is asserted that this fact was reflected on the police radiogram dated so and so, and only the selected candidates were called to appear for personal interview on the dates fixed on so and so. These fixed dates were such and such, and as has been submitted between so and so. It is very frankly contended in the counter affidavit that those who were left out due to paucity of time were called on so and so. The counter also goes on to explain that the interview board was alive to the consideration of the required selection of the post of constables, and as such, it was sufficient to test the candidates on the basis of their physical capability and agility. It is then contended that in viva voce, random questions were put to the candidates considering the time constraints to ascertain their minimum intelligence level, which a constable is required to possess, the copies of etc. So, paucity of the time, which prima facie appeared to be a deterrent factor in assessing the suitability or, my lord, the eligibility of the persons. Again, my lord, has been highlighted over here, and the Supreme Court deals with it. Then, my lord, 56, 58, I skip over for that time being. No, 58 now. 56 I skip over. 58 is very important for me. What is yes. And who were examined? Some of the petitioners and the interviewers, some of the interviewers. But here, my lord, the Supreme Court says that even the report of the amicus cannot be looked into. Even the report of a scrutiny team cannot be looked into.
Yes.
And in our case, my lord, the court had taken upon itself the burden of a prosecutor. I consciously use this expression prosecutor because I have a point of predisposition.
Yes.
But may I read further? while testing the fairness of the selection process, wherein thousands of candidates were involved, the High Court should have been slow in relying upon such microscopic findings. It is not for the High Court to place itself into the position of a fact-finding commission. That too more particularly at the instance of those petitioners who are unsuccessful candidates.
Yes.
But the first is the bar to undertake this kind of an inquiry, roving inquiry. And second, what is more important is at whose instance? At the instance of unsuccessful people.
Yes.
The High Court should therefore have restricted itself to the pleadings and the say of the respondents. Unfortunately, the High Court took it upon itself the task of substituting itself for the selection committee, and also in the process assumed the role of an appellate tribunal, which was in our opinion not proper. Thus, the High Court converted this writ petition into a public interest litigation without any justification. Milord, where, Milord, the court had only appointed amicus and a scrutiny team and had decided the matter on those two bases, Milord, the Supreme Court is coming down heavily on the High Court. And what is my case? My case is the judge had become the prosecutor. So this paragraph 58 clinches all points. Roving inquiry, unsuccessful candidates, substituting itself into a fact-finding tribunal.
Mr. Dotto, is it possible for a participant at the time of filing the writ petition to ascertain what you have done in your chambers? You have prepared this interview issue, which you are saying he acts as himself as the prosecutor. We are wanting to get an answer from you. You are heavily relying upon the averments made. What more the averments could have been made by the participants?
Milord,
they say there is a scam, and these are the examples of it, some which you have relied, para 11 and 14. What we want to know is, seeing it from the perspective of the participating candidate, is it possible for him to ascertain what the board has done in its meetings, who have been appointed, whether any, what would be your answer to, because this would be their argument in counter.
There are two things. First is, Milord, there is a difference between a scam and a corruption.
We are awaiting to hear what
Yes,
you are saying.
I'll come to those. Scam was not a case made out.
Then, Mr. Dotto, you finish this up and come to the topic.
Yes. But two judgments on this,
Yes,
and then, Milord, on the corruption aspect, Milord,
Sorry,
I can appreciate, Milord, it's troubling the court. I can quite appreciate. I'll immediately take the corruption as my next point.
Then you have showed us paragraph 60 and
58 was the last paragraph I placed.
You want to place 60 and 62.
60 and 62.
Yes.
In our opinion, the first basic thing for such a selection process would be lack of bona fides. This is the clinching issue. Lack of bona fides, or as the case may be, malafide exercise of powers by those who were at the helm of the selection process.
Yes, this is what.
This is the only, Milord, exception that the Supreme Court makes.
Here you are that.
Yes, there is no allegation of malafide. No case made out of lack of bona fides and malafides. That couldn't have been, because the people over here are coming for an employment. I cannot say that the process is malafide and then say, give me employment. Those two cannot go side by side. These cannot go parallelly. Therefore, when a petitioner comes saying that X have been appointed, I stand on the same footing, I should also be given appointment, then it cannot be said that X has been appointed through a malafide process. He has to say that the process by which X has been appointed is correct, but I have been discriminated in that correct process.
No, that in fact leads to their submission that unless you cancel those appointment, how we get in?
No, that is not the case. Very well, I'll address your lordship on that also. I'll address your lordship on that also.
Yes. All right, we ask.
Yes.
Now paragraph 62.
60, my lord, the third line. Both the courts below have not recorded any finding that they found any malafides on the part of any of the state officials who headed the interviews. On the other hand, the tenor of the judgment showed that the whole process did not suffer from malafide, lack of bona fides, bias or political interference. But these are the parameters, my lord, set down by the courts, because otherwise, my lord, all recruitments will be susceptible to all kinds of suspicion. My lord, unsuccessful people, my lord, have a tendency to point fingers at the process. Everywhere it is the same.
Yes.
That is why, my lord, your lordships have held in innumerable judgments that unsuccessful persons should not be entertained in before the court unless a very, very strong case is made out.
Yes.
Then, my lord, in Union of India versus Vikas Konar, when a selection committee recommends selection of a person, the same cannot be presumed to have been done in a mechanical manner in absence of any allegation of favoritism or bias. A presumption arises in regard to correctness of official act. A party who makes any allegation of bias or favoritism is required to prove the same. It is their burden. And in our case, my lord, the court takes up the burden.
Yes.
In the instant case, no such allegation was made. The selection process was not found to be vitiated. No illegality was brought to our notice. Therefore, my lord, the immediate query of the court is answered, my lord, in Vikas Konar's case. That one who alleges bias, malafide, corruption, XYZ, the burden is on him to prove. It is not for the court to make a roving inquiry. And these allegations, my lord, if they are made in the vacuum, with the catch expression corruption, the catch expression scam, then your lordships would be burdened with all kinds of litigations.
Yes.
Then kindly take me to the last paragraph of this judgment, para 52. 62, I'm sorry, 62.
Yes.
We have already shown in the earlier part of the judgment that there were proper advertisements. In our case, no dispute on that. Reasonable procedure was chalked out in the earlier meetings, held by the authorities. Even the guidelines were defined, Miller 2016 recruitment rules, and interviews proceeded along with those guidelines. A mere expression of doubts only on the ground of large number of candidates appearing and there being not objectively and properly tested without any further material, in our opinion, cannot by itself render the whole selection process illegal. But what is the case? No aptitude test was taken. At the highest. At the highest, the case is that no aptitude test has been taken. Though it is not. Assume it to be correct for the time being. But the Supreme Court says that that by itself does not render the whole selection illegal.
Yes.
But I can understand no advertisement made. I can understand interviews were fixed on X date, it was taken on Y date. People could not participate. I can understand, Millard, there were lack of interviewers. I can understand fourth class staff conducting the interview. Something of that sort. So at the highest, Millard, with all the roving inquiry, what the court comes to the conclusion is that aptitude test has not been taken.
Yes.
Therefore, my lord, this is what, my lord, the Supreme Court lays down the parameters in where large number of candidates for large number of posts are conducted, recruitment process is conducted. My lord, the only exception is malafides, lack of bona fides against officials. Well, the Supreme Court did not use the expression identified officers. Kindly permit me to use the expression identified officers. You cannot say officers of the board. You have to point out someone. And that is what, with respect, the judge wanted to do. He wanted the previous president of the board to be called from the custody at 3 o'clock and cross-examine him.
Yes.
Well, the entire, the writ, with respect, kindly do not take me amiss. The entire writ jurisprudence has been rewritten in this case.
Yes. Next.
Well, what your lordships have prohibited all along is what has been adopted in this case. Now, kindly take note a later judgment on the same lines, 2023. अच्छा ना अच्छा दी दे मतलब this अच्छा दी दे मतलब this Sadananda hello was also followed in our High Court, Milord, in 2017 SCC online cal 3799 but this is that civic volunteers case, Milord. The learned single judge, Milord, had passed orders, Milord, interfering with the appointments, went up for appeal.
Yes.
Please take Milord paragraph 10. But we have to confine ourselves to the law which has been laid down by the Supreme Court.
Yes. Yes.
He further submits that no malafide has been alleged against the successful candidates and the learned judge erred in interfering with the decisions of professionally qualified authorities. The court has conducted a roving inquiry on the factual aspect which is not permissible. While testing the fairness of the selection process, wherein thousands of candidates were involved, the learned judge should have been slow in forming an opinion as regards the entire recruitment process on the basis of the manner in which the selection process was conducted in 2 police stations, and that too without granting any opportunity of hearing to the candidates selected in this process. Candidates are not parties over here, the 36,000 persons.
Yes.
In support of such contention, reliance has been placed on so and so. Then please take me to paragraph 18.
This we will go through, Mr.
Yes.
Paragraph 18.
Yes. Heard the learned advocates appearing for the respective parties and considered the materials on record. It is well settled that even though the power granted to the executive authority is not totally immune from judicial review, but the court makes an almost extreme presumption in favor of bona fide exercise of such power. Bona fide exercise of such power. The 2 indispensable riders for scrutinizing the validity of a recruitment process conducted by the government are to prevent miscarriage of justice and to secure fair play in action. It is the impact of the action that would define the nature of the procedure that is to be adopted. On one hand, the civil consequence of an order, particularly one that visits the person with the harsh consequences of his engagement being cancelled. And on the other hand, Milord, to be very honest, Milord, this part I will not argue because this is for the affected persons. But since it is a fallout of the previous discussion, therefore, I have just read it, a part of it, Milord, the rest I will not place. I'm sure, Milord, the learned councils would place those. Then kindly take para 23.
Yes.
In the pleadings, this is our High Court holding. There is no allegation of malafide on the part of any state officials. But I use the expression identified officers. Here, Millard, our division bench has also said so. No allegations of malafide on the part of any state officials who were in the interview board. There is also no allegation of any bias or favoritism. The recruitment process was set aside since it appeared to the learned judge that it was an impossibility on the part of the selection committee to interview 1351 candidates at so-and-so police station and so-and-so candidate in so-and-so police station respectively on a single day. Before arriving at such finding, the learned judge did not perhaps notice the contents of the order of 28th of April in which it stood recorded that the petitioner says that he participated in one of the group interviews. That is in the fact of that case. In the case of Sadananda Hello, it has been observed that no benchmark can be set as regards the highest number of candidates to be interviewed on a single day. It depends upon the post for which such interview is conducted, the nature of the duty attached to that post, the nature of the test to be applied, and other ground realities. The learned judge, while setting aside the recruitment process in the police stations at so-and-so, issued directions towards the annulment of engagement of CPVs all over the state subject to an inquiry to be conducted by the committee. The last direction was supplemented by a further direction that all engagement of CPVs in the rest of the state cannot be extended beyond the state calendar year. This rider supplemented renders the decision towards the constitution of a committee and holding of an inquiry by the state committee to be an ideal formality. In the absence of any specific or categorical finding supported by any concrete and relevant material, that widespread infirmities of an all-pervasive nature, which could be really said to have undermined the very process itself in its entirety or as a whole, there was hardly any justification in law to interfere with the engagement of 130,000 CPVs all over the state at the instance of 9 unsuccessful candidates, and that too 3 years after such engagements. From the nature of the directions contained in the impugned order, it appears that the learned judge has treated the matters as public interest litigation. It is true that then it's not required, so and so.
Next, Mr. Dotto.
Therefore, this is the only exception. In our case, I will, if required, once again take your lordship through the petition, no allegations of malafide.
Yes.
Now kindly see, Lord, a later judgment of 2023.
Same point.
Same point with the addition that permissibility of judicial review. 5 paragraphs. No. This is 2013. 2023, volume 17, Supreme Court cases, page 147.
Paragraphs?
Miller, paragraphs 21.3, 21.6, 21.8, 39 and 40.
Yes. We shall go through it, Mr. Dotto. The paragraphs we have taken note of. You need not go through all the paragraphs.
Yeah, please permit me to read on the judicial review aspect. The other parts are, my lord, is what was held in Sadananda Hello. Kindly take me at para 31. Same judge.
Yes.
Before proceeding further, where the heading is selection process for public employment interference by court. Before proceeding further, it is necessary to preface our judgment with the view that courts in India generally avoid interfering in the selection process of public employment, recognizing the importance of maintaining the autonomy and the integrity of the selection process. The courts recognize that the process of selection involves a high degree of expertise and discretion, and that it is not appropriate for courts to substitute their judgment for that of a selection committee. It would be indeed treading on a thin ice for us if we were to venture into reviewing the decision of experts who form a part of a selection board. The law on the scope of extent of judicial review of a selection process and results thereof may be understood on consideration of the following case law. In Dalpat Swanso, Miller paragraph 12 of quoted.
We shall go through it. We shall go through.
Miller para 32, kindly Miller have a look to para 32, para 33, para 34. These are all the judgments where on Miller public employment. Then para 35. Yes. Then para 36, judicial review part. Thus, the inexorable conclusion that can be drawn is that it is not within the domain of the courts exercising the power of judicial review to enter into the merits of a selection process, a task which is the prerogative of and is within the expert domain of a selection committee, subject of course to a caveat that if there are, but this is the caveat, if there are proven allegations of misfeasance or violation of statutory rules, only in such cases of inherent arbitrariness can the court intervene. The exception is also given. One exception here, Lordship had found in Sadananda Hello. The other exception over here is malfeasance and violation of statutory rules.
Yes.
Thus the court, para 37. Thus the court, while exercising power of judicial review, cannot step into the shoes of the selection committee or assume an appellate role to examine whether the marks awarded, but this is very important. But one paragraph here, Lordship remembers, kindly recollects, that high marks were given in Vivavosi.
Yes.
This is where, my lord, the Supreme Court speaks otherwise. And examine whether the marks awarded by the selection committee in Vivavosi are excessive and not corresponding to their performance in the test. The assessment and evaluation of the performance of candidates appearing before the selection committee interview should be best left to the members of the committee in the light of the position that a court cannot sit in appeal against the decision taken pursuant to a reasonably sound selection process. But kindly mark, Miller, this phrase, reasonably sound selection process. The following grounds raised by the petitioners, which are based on attack of subjective criteria employed by the selection board interview panel in assessing the suitability of the candidates, namely the candidates who have undergone post-graduation, had been awarded 10 marks, and in the Viva process, such PG candidates have been granted 18 marks or 20 marks out of 20, that although the petitioner had performed exceptionally well in the interview, the authorities had acted in an arbitrary manner while carrying out the selection process, would not hold any water. So arbitrariness again doesn't hold water. Then, Millard,
39 and 40.
38 is also important, kindly see. All these aspects have been gone into. The next aspect of the matter which requires consideration is the contention of the petitioners to the effect that the entire selection process was vitiated as eligibility criteria enshrined in the advertisement. Notice was recast vide a corrigendum, without any justifiable reason in order to consider this contention, regard may be had to the following case laws. Again, 38.1 says unsuccessful candidates not to be entertained.
Yes.
But the entire 38, Millard, your lordships would find, Millard, number of judgments considered by the Supreme Court, and in 39, the Supreme Court says that having taken part in the selection process without demur, someone cannot challenge.
Yes.
And finally, Millard, Shodanando Hello has been followed at para 40. Which says that the only exception is malafides. Now, Millard, I come to, Millard, the point which is possibly troubling the court, corruption. I start from the writ petition. Millard, the pleadings of corruption, Millard, are at paragraphs
Paragraph 18, I think.
12. Pleadings of corruption are at paragraphs 12, 14, 15, 17, 18, and 22.
Yes.
Millard, let us see, Millard, what is the case made out of corruption. First is para 12. Your petitioner state that recently the TET 14 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this court, the petitioners came to know that several illegal appointments have been given, depriving the petitioners. Non-trained candidates are the worst sufferer of this scam. On 23/12/2020, the West Bengal so-and-so published one notification for recruitment of so-and-so primary teachers. No. Of so-and-so, and in that publication, they have stated that the candidate should possess the qualifications as per guidelines of NCT. The notification is absolutely illegal. As per qualification should be measured as on the date of qualifying TET 14. Strangely, in TET 14, candidates named as Mr. Y was impaneled. A person named Y having roll number so-and-so was impaneled by the board, and it also proves that huge corruption took place. As per the action of the board and as per different statements given by the then president of the board, all trained candidates were recruited, and as per the notification of the board, the petitioner should get a fair chance of recruitment, but the board has done a complete injustice to them. It is the stand of the board that non-trained candidates cannot be appointed. If it is the stand of the board that non-trained candidates cannot be appointed, then all appointment post March 2016 are bad in law. Board should apply same theory to everyone, and the board cannot simply pick and choose between the candidates. The petitioners are TET 14 candidates, and they deserve the same relaxation which was granted to other non-trained candidates. But two things that I would submit over here. But this paragraph speaks of TET 14, so alleged corruption, and speaks of a recruitment process undertaken on 23rd of December 2020. We are not concerned about 2020 recruitment process. We are concerned about 2016 recruitment process. So the allegations of corruption are in respect of TET 2014 and 2020 recruitment process. We are dealing with a 2016 recruitment process. Yes. But Millard, this person Y is of 2016. This I must tell the court. Then kindly take, Millard, para 14.
14. Yes.
This is the next pleading of corruption. Your petitioner states that at present, there is more than 1 lakh vacancy in the Education Department of West Bengal. Since 2011, several exams were conducted to fill up the vacancies in schools, but a single recruitment procedure could not be completed without corruption and irregularities. The qualified students were not selected, and the students who did not have any qualification were selected, and they were working in the department as teachers. So this is on the assumption that since the others were for other process were full of corruption, therefore this is also so.
Yes.
Then the next is, it is not their averment, I mean, not their statement, it is the statement of an MP, para 15. Your petitioner further states that on so-and-so member of the parliament made a statement before the media pointing irregularities in TET panel. Recently, a person lodged a complaint against one MLA of so-and-so, alleging that the MLA took crores of money, crores of money from job aspirants with a promise to give them government job in school, and in that case, personal assistant of so-and-so MLA of so-and-so was arrested. The statement of so-and-so is described. So this is what they gather from the newspaper. Then Millard, para 17. Your petitioner states that TET 14 is the biggest scam of the Education Department of West Bengal, and in this case, the ministers of the state of West Bengal, MPs, MLAs, leaders of the ruling party are involved, and meritorious students who qualified for the job did not get chance. And after talking to the candidates, the petitioners came to know that roughly 14 to 20 lakh rupees were taken for giving job in TET 2014. Some people did not get job even after giving the money, but they could not open their mouth due to threat of the members of the ruling party. Whatever it is of TET 2014, nothing to do with recruitment of 2016. Then Millard, the next paragraph is para 18. Your petitioner states that the board has stated in different cases filed before this court that 42,897 candidates were selected till date, but no merit list of so-and-so were published. The board should be directed to publish, etc. The corruption part is a bit towards the end. Kindly take the last 3 lines of that page, page 42. Persons who did not qualify for the TET 14 was appointed as primary teacher by the board, and in spite of specific case, steps were not taken, and it shows that there was corruption and illegal financial transaction while conducting the recruitment process. The department ought to have taken suo motu steps, but that was not done for the reasons best known to them. Moreover, many candidates complained that TET 14 qualified certificates were not issued to them, and even today they are fighting for that. There is no delay in filing the public interest litigation as corruption is continuing, and the Honorable Single Bench of this court also passed several orders regarding TET 14 in September 22, and absolute fraud has been committed by the board in not publishing merit list of TET 14 qualified candidates. Everything relating to TET 14. And they describe it as a public interest litigation. This is what the Supreme Court says, that you should not treat it as a public interest litigation. Then kindly take the last paragraph, para 22.
Yes.
Your petitioner states that since 2011, not a single recruitment was done by the state of West Bengal without any corruption and illegality. Time to time, this honorable court had to interfere, and still the same corruption is prevailing. The persons who were involved in TET 14 scam are holding different posts under the government of West Bengal, and the candidates who suffered due to the scam are facing hardship. The petitioners were subjected to complete injustice by the department. Your petitioner states that the respondents and each of them acted arbitrarily, etc. In appointing some candidates who did not even sit for the TET 14, and as such, this honorable court pushed judicial.
Yes.
So confined to TET 14, the word corruption has been used out of context in my very humble submission, but we'll deal with that. Now, kindly see, my lord, the judgment of the Honorable Court on the corruption aspect. Then, my lord, I'll address the court. What is corruption? What is scam?
No, before that, you show us the process, selection process, the notification and the procedure you follow.
Yes, that definitely I'll follow. I'll demonstrate. But, my lord, on the corruption aspect, this is the pleading and what is the finding of the court. Please have a look. Keshav?
So that you have showed us that the court itself acted as a prosecutor.
Yes, that is one aspect. The other aspect is on corruption, what is the finding of the court? But the judgment starts at page 611.
Yes.
Now, please take me that internal page 9 of the judgment, running page 618, third volume.
Yes.
Third volume.
In support of the allegations
Yes.
of corruption.
In support of their allegation as to corruption, in awarding marks, in the interview, the petitioner has filed a booklet, spiral binding, of 121 pages, on the basis of which it has been alleged that candidates whose marks were very poor in secondary, in higher secondary, and in TET has been given 9.5 out of and 10, that is full marks, out of full marks, 10, that is perfect 10, in the interview and aptitude test. Then within bracket, no aptitude test was taken at all. And the allegation that there was no aptitude test, which has been proved before me from evidence of the candidates and from interviewers which are kept on record. Here to elicit the truth, I had to exercise power under 165, but I'll address separately. For example, some particulars has been given in the said 121 pages booklet, spiral binding, which has been prepared from the particulars published in the web portal of the board. By the board, some candidates' marks are reproduced herein below, which shows that the marks awarded to such candidates whose results are very poor in secondary and higher secondary examination and also in TET are wholly absurd assessment in interview. And unless some extraneous factors, which include corruption, as has been alleged by the petitioners, and how has come to light from the investigation by CBI and ED, I do not know which report says so, but the court considers this, such absurd marking could not have been made by the interview boards in different districts. While looking to the following particulars, it has been noted by me that in academic assessment and TET, the maximum marks that could have been given were the same thing, 10 out of 10.
Now, where is this compilation of this 120?
Well, that is in the paper book, but Millard, this was not part of any pleading.
Compilation
It's in our from the those pages also, keeping my point open that spiral binding could not have been looked into, but still then, since the judge, honorable court has looked into it. Now I give an example of a candidate where the court gives an example where in the entire judgment your lordship will not find where any submission of the petitioners, unfortunately. Now I give example of a candidate before giving a table prepared from the document on record, that is 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in higher secondary out of 10, totaling to 7.378, but has been awarded 9.0 marks in interview and aptitude test not taken out of 10. whose total score became 16.878 and thus became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from particulars published by the board. Then we had a list. How many names have been given? 53, only 53.
Yes.
But Millard, the Honorable Court does not take into consideration there are thousands of cases just the opposite. High marks in academics and low marks in Viva-voce aptitude. It's not looked into by the court. Where those papers are on record, I'll demonstrate from that when I take up this point on the aptitude test part. Then kindly skip over 2 paragraphs, kindly take para 17. So according to the court, 53 candidates granted high marks in Viva-voce.
For that the entire
The entire process should go. That is the approach of the court.
Yes.
Then please take Millard paragraph number 17, where I only draw your lordship's attention to the corruption aspect part. From the gross illegality in the selection procedure in the recruitment exercise of so-and-so conducted by the board, we're pausing here for a moment, Millard. There was no allegation of corruption in 2016. I've taken your lordship through the pleadings. Whatever corruption alleged, right, wrong, TET 2014. It is clear that the board and its officials, including its former president, who is now in custody after arrest by the Enforcement Directorate for transaction of huge money in the recruitment procedure, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs for primary school teachers were actually sold to some candidates who had the money to purchase the employment. A corruption of this magnitude was never known to the state of West Bengal. The former minister, former president, and a number of middlemen through whom jobs were sold like commodity are now behind the bars, and the CBI ED investigation is being continued in full swing. This paragraph. It can come in this paragraph provided the judge is examined as a witness. 1871 Indian Appeals made, I'm going to place.
Yes.
How can the court import its personal knowledge in the matter? Which CBI, which ED, which investigation? Where are those documents in the records of this proceeding?
Did you argue this in the appeal which was preferred against this order, interim order appeal? So this personal knowledge of the single judge was not argued, which you are.
No, that was interim order, Millard.
Yes,
This is the final one.
Judgment of Justice Subroto Talukdar.
Yeah, that was at the interim order stage.
Yes, yes.
Yes, yes.
That ground was not taken by you.
Millard, this is a point of law, Millard. I can take it even in a collateral proceeding, Millard. Even in a collateral proceeding, Millard, I can take it.
Yes, next.
Then kindly take paragraph 18. It is a matter to be noted that the board in its affidavit in opposition while dealing with all pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that that sense of justice is much above sense of law. If the writ application is thrown out on such niceties of law, as this will appear that in the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience.
Yes, yes. You have placed this, Mr. Not placed this.
So constitutional conscience, I must say that in this recruitment scam, stinking rats are being smelled. The board placed some judgments before me in support of the niceties of legal principles, which I do not find have any applicability in the fact of the magnitude of stinking corruption in the recruitment exercise of 2016 conducted by the board. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much above the ground realities.
So you now want us to deal with your judgments?
No. I have
the judgments which we have cited,
yes,
before the learned single judge, that were
with
not,
respect, it is not even noted.
it was not.
If somebody tells me that no, you have not cited this judgment, I can't say anything.
Yes.
But the minimum that I can expect is the judge will at least note that so and so has submitted ABCD judgments.
Is
Yes,
it to
but
be
not
submitted? Mr. Dotto, Advocate General, argues it is to be submitted.
Yes. Then last paragraph, kindly take me at para 25.
Yes.
This whole imbroglio, including corruption involved in the matter, has taken place due to the former president of the board who knew the rules of recruitment but violated the rules, and therefore, if the government thinks the entire expense for holding of the recruitment exercise can be realized from the estate of such and such. So the corruption is infraction of the rules. Para 25 is very important. Finding is corruption based on infraction of rule.
Yes.
But now, infraction of a rule can be an irregularity, can be a lapse, can be a departure, but it cannot be corruption. Now, what is corruption? And I'll place judgments on that. But simply saying corruption does not make it a corruption. The judgment of record. 7 7 আর 4 9. Please take me, Lord, Black's Law Dictionary, 10th edition. At the second page, Milord, page 421, please take the right-hand side column at the bottom. But the meaning of corrupt is said to change someone's behavior, morals, or principles from good to bad, to pervert the integrity of, to change the traditional and established form of culture, language, etc., so that it becomes worse than what it was before, to destroy or diminish the quality and usefulness of an electronic or mechanical device or its component, archaic, to impose corruption of blood on a person. Now, what is corruption? Kindly turn the page. The left-hand side top.
Page?
With the next page, page 422. এই ভুল আছে নাকি? 20 বললাম।
Which page?
There are two pages, 421 and 422.
Oh, you put My copy 21 given at the bottom. Yes.
Oh, I'm so sorry, Milord. I'm sorry.
Yes, corrupt.
But
No, it's okay. It's okay. Yes.
now please take note 422.
Yes.
Corruption is defined as depravity, perversion or taint, and impairment of integrity, virtue or moral principle, especially the impairment of a public official's duties by bribery. The word corruption indicates impurity or debasement, and when found in the criminal law, it means depravity or gross impropriety. Then two is a fiduciary's or official's use of a station or office to procure some benefit either personally or for someone else, contrary to the rights of others, an act carried out with the intent of giving some advantage inconsistent with the official duties or rights of others. This is, Milord, the traditional definition of corruption.
Yes.
The important or the relevant part over here in our case is impairment of public officials' duties by bribery. First is, Milord, here we do not have any identified public official. You cannot just say given money, taken money, sold job, given jobs to the less meritorious in a case of corruption. It has to be Mr. X found. First of all, Milord, this is not a proceeding in which this can be gone into. Be that as it may, Milord, fundamentally speaking, Milord, in a case of corruption, a person has to be identified and proved that he has indulged in corruption through bribery, illegal gratification, etc. Now, how, Milord, the expression corruption is being defined in judgments of the Supreme Court? Please take, Milord, 2004. Or first, kindly take 97 theta বের করতে হবে 97 theta বের করতে উঠে 97 3 আরেকটা দাও পেজ 403 হ্যাঁ kindly first take 1997 volume 3 Supreme Court cases page 483 এই আরেকটা কপি আছে এই আমারই তো নেই না দাদা payment of back wages would provide an impetus and put premium on corruption. The society has to pay the price for corrupt officers for public exchequer. Therefore, when the court directs payment of back wages on reinstatement, the court tribunal is required to consider the backdrop of the circumstances and pragmatically apply the principle to the given set of facts. No abstract principle of universal application could be laid in that behalf. The confidential report of the officer prior to initiation of the prosecution do furnish evidence of conduct of the public official. It is the duty of the officer to place his material and of the government to place all other necessary records in that behalf before the court tribunal consideration, and it would be for the court tribunal to consider and decide the matter. This court has
back wages payment.
Yes, this is a back wages case, but Miller, two things are important over here. First, it says that it is an unsatiated greed for wealth, and again, where I am saying where a public official has to be identified,
Yes.
and there has to be exchange of money, illegal gratification demand,
Yes.
and Miller handing over. Kindly take me at the next judgment of 2004-9 Supreme Court cases. 319. 2004 Volume 9 Supreme Court cases 319. 319. Kindly take only one paragraph, paragraph 3.
Thank God. Yes.
Corruption as such has reached dangerous heights and dangerous potentialities. The word corruption has a wide connotation and embraces almost all the spheres of our day-to-day life and world over. In a limited sense, it connotes allowing decisions and actions of a person to be influenced not by rights or wrongs of a cause,
But by the prospects of
but by the prospects of monetary gains or other selfish considerations. Avarice in a common frailty of mankind, and while Robert Walpole's observation that every man has a price may be a little generalized, but it cannot be gainsaid that it is not far from truth. Burke cautioned, among a people generally corrupt, liberty cannot last long. Therefore, monetary gains and other selfish consideration is the other expression used by the Supreme Court. But our High Court in 1994, which is very important, I feel, for my case, is that specific instances of corruption has to be highlighted.
like fraud,
yes,
or apart than fraud. Yes. उनके पार्टी को yes.
But one judgment before the Calcutta High Court, please take me, Lord, 2007, Volume 7, Supreme Court cases 358. 2007, Volume 7, Supreme Court cases 358.
How many more do you have in your bag?
But this being the most important aspect, but about 7-8 on corruption.
7-8.
But 2007, Volume 7, Supreme Court cases 358, only one paragraph. But the same thing by the same honorable judge. Paragraph 3. Kindly note down the paragraph. I don't need to place it.
Paragraph 3.
But same as 2004-9.
Yes.
Now please take note of our High Court judgment.
Paragraph.
Where the honorable single judge's judgment plus. Where this is AIR 1994 Calcutta 10. This is under 226. Please take only one paragraph. Paragraph 5.
Yes.
As regards the general allegation of corruption, as made by the petitioners, the same cannot be adequately dealt with unless specific instances of corruptions are brought to light.
You make a scam.
However, even general allegation of corruption and malpractices, if it continues to be consistently articulated for long, is likely to expose the concerned department to disgraceful suspension in public mind and thereby tarnish its credibility in the matter of discharge of assigned responsibility. In public interest as well as in the interest of department itself, it is therefore highly desirable that the departmental authorities should look into the matter with circumspection for ascertaining whether there is any truth in the general allegations and to take steps to plug the loopholes of malpractices if there be any. The petitioners are granted, etc. Therefore, my lord, there has to be specific instances of corruption.
Yes.
Then what is to be proved now? In an allegation of corruption, in a case of corruption, what is to be proved? But please have a look to this judgment of 2023, Volume 4, Supreme Court Cases, 731 pages. Yes, issue is. But I'll place a few paragraphs of this judgment. Paragraphs 19, 37, 47, and a few subparagraphs from paragraph 88 and 76. 19, 37, 47, 73, 88.
Yes.
In P. Satyanarayana Murthy, reference was made to two cases, namely so and so. In the first of the aforesaid two cases, it was observed that the prosecution has to prove the charge under section so and so, like in any criminal offense, and that the accused should be considered to be innocent till it is established otherwise by proper proof of demand and acceptance of illegal gratification, which are the vital ingredients necessary to be proved to record a conviction. In CP Rao, which is the second of the two cases referred to in so and so, it was observed that this court, by this court, that mere recovery by itself would not prove the charge against the accused in the absence of any evidence to prove the payment of bribe and to show that the accused had voluntarily accepted the money, knowing it to be bribe, the conviction could not be sustained. Then, my lord, the next is para 37. There has to be demand and delivery.
Yes.
that the presumption under section 20 of the Act would apply only if the fact of demand and acceptance of illegal gratification, as the case may be, is proved. Such a proof can be adduced even by way of a circumstantial evidence in the absence of direct evidence. This would be so particularly in trap cases, as the prosecution has to prove that the accused had demanded a bribe from the complainant. The factum of demand can either be proved by direct evidence or through circumstantial evidence. Then, my lord, para 47. In para 47, my lord, provisions of the Evidence Act is considered, but I'll take it separately. For the time being, your lordships may skip over para 47. Now, please take para 76. Satyanarayana Murthy has been referred to in the state of so-and-so. By observing that what constitutes illegal gratification is a question of law, whether on the evidence let in, crime has been committed or not is a question of fact. If therefore the evidence regarding the demand and acceptance of a bribe leaves room for doubt and does not displace wholly the presumption of innocence, the charge cannot be said to be established. The court also made observations regarding framing of a charge in a criminal trial, where the court is expected to apply its mind to the record and documents placed therewith before the court. It was also held that a proof of demand is an indispensable mandate for the offence under section 7 and 13 of the Act. On the facts of the case, it was held that the same was absent and the accused was liable to be acquitted. Then a few subparagraphs from para 88. What emerges from the aforesaid discussion is summarized as under: A. Proof of demand and acceptance of illegal gratification by a public servant as a fact in issue by the prosecution is a sine qua non in order to establish the guilt of the accused public servant. Then 3. Further, the fact in issue, namely the proof of demand and acceptance of illegal gratification, can also be proved by circumstantial evidence in the absence of direct oral and documentary evidence. In order to prove the fact in issue, namely the demand and acceptance of illegal gratification by the public servant, the following aspects must be borne in mind, but I don't trouble the court with those aspects. Then E, when inference can come in. Please stay 88.5. It may be said that I don't have any evidence before me. The court should infer. When should the court infer? Kindly take 88.5. The presumption of fact that with regard to demand and acceptance or obtainment of an illegal gratification may be made by a court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in absence thereof. On the basis of material on record, the court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Of course, a presumption of fact is subject to rebuttal by the accused. In the absence of rebuttal, presumption stands. Therefore, my lord, the court needs some foundational facts also. Just pointing fingers is not foundational facts. Just assumption that everything was bad, therefore this is also bad. These are not foundational facts. And what is the corruption alleged or found finally? Departure from the rules. Therefore, the first question which would arise for your lordship's determination is, going by the findings of the court, that there has been a departure from the rules. Let us take it to be a deliberate departure. Let us for the time being assuming it to be a deliberate departure. Though I don't accept it, I will prove that there was no departure. Presume for argument's sake that there is a deliberate departure. Where is the allegation of exchange of money? Where are those foundational facts? Therefore, my lord, my one-line answer is, or one-line submission is, a departure from a recruitment rule, proved or otherwise, cannot tantamount to corruption.
Yes.
But there are two 2025 judgments on vague allegations. These are just vague allegation, assumption. That was bad, those were bad, so this is also bad. But everybody is swayed by this expression corruption.
Are you required to place those because you have placed NIDAs?
Just my lord, on the vague allegation, because my case is that your lordships have seen the pleadings. My lords have also gone through the judgment on the corruption aspect.
You can give the citations.
Yes, yes. My lord, the first one is 2025 SCC online SC 17 paragraph is 13
And the other one?
The other one is 2025 SCC online SC 441 para 22.
Yes.
Kindly similar here, the Supreme Court says in the first one, that is page 17, para 13, just one sentence. Please take the second sentence at para 13. That apart, besides the vague allegations, rest of them, even if they are taken as true, would not disclose commission of any offense or make out a case against the appellant. But these are, my lord, against, my lord, identified officers, pointing allegations against named persons, FIR registered. Then also Supreme Court says vague allegations do not constitute corruption. Please take the last one.
Paragraph 22.
Paragraph 22. The allegation over here is misuse of authority. The erstwhile president of the board has been, remarks have been passed against him. Kindly similar there, paragraph 22. The only charge is with respect to misuse of authority, which does not come under the provisions of the Prevention of Corruption Act, and none of the ingredients regarding demand or obtaining or acceptance of bribe or any illegal gratification has come out. The accusation was only that the policy of the state required a tender process, etc. Millard, kindly take the next page. The investigation report, as we observed, speaks only of an allegation of misuse of authority without any allegation of demand and acceptance of bribe as against the appellant. The presumption of section 20 is false. Misuse of authority is again not a corruption. There is no allegations of demand and acceptance.
Yes, Mr.
Millard, would your lordship permit me to come back after the vacation? Before the vacation is very difficult. It's really very difficult. I know, Millard, it's a
Mr. Dotto, we have allowed you to place all the judgment. We do not want to shut it off, but how more time will you be taking?
But I'll take at least 2 halves. 2 second halves.
You said 1 half is enough.
No, it's not enough. The more I read, I find, well, I've not even canvassed 2 of my 10 points.
You will get a chance to reply,
No,
no?
but unless, my lord, I place it, my lord, they don't get a chance to rebut.
It becomes an impossibility to finish it off.
My lord, the problem is, my lord, the way this matter has been dealt. I'm so sorry to say, my lord, after conclusion of hearing of the petitioners, then, my lord, I begged and got an opportunity to file an opposition. And I take responsibility of saying, my lord, kindly do not take me amiss. It may not sound proper, fair. But the petitioners did not utter a single sentence in which are reflected in the judgment.
You are for the petitioners.
No.
I am for additional party, which is already under. I am for
No,
that
they-
party.
Who are the petitioners? So, Mr. Mojumdar, how much time will you take? Because we are not being to fathom it out, because the arguments which have been advanced, these you must have to deal with it, no?
We will deal.
How?
There are,
Mr. Dotto, please.
with the candidates, there was a specific direction by the Honorable Supreme Court also, since we are not heard.
Yes, we have seen that. We are not saying we will not hear you. This order is with us. You have placed it before us.
But kindly keep it after the vacation. Give me 2 days, my lord, I'll finish.
Yeah, Mr. Dotto, curtail it to a single day. Mr. Don't take it. We just don't feel like stopping the.
No, I quite appreciate, but I appreciate the burden of the court also, my lord.
Please, I would say you agree to dates. You give us a fixture. My brother is here. We will fix it up and finish it up. Because I don't know whether how.
Honored counsels representing the added parties won't be making their submission except one or two. That's what.
No. First of all, after he finishes, we want to hear the writ petitioners.
I was suggesting this, that since all of them would be selling on the same board, worship here whosoever supports the appeal, so that I can give a comprehensive reply.
And Mr. Bhattacharya, I am led by Mr. Bhattacharya. Mr. Bhattacharya, to only take 1 hour.
You are appearing for whom? The added person.
Supporting the writ petitioner, which is already allowed in as a form of can 2, my lord, added respondent. Added
The
respondent.
added respondent.
Yes, my lord.
No, not at all. Not added.
My lord, in can 2, in the first order, I have added. Kindly read it. And they never opposed in the way of affidavit. That was the direction on the first order.
We know, we have been told, Supreme Court has said, we will listen to you, sir.
They are saying that we stand on the footing of the writ petition. It is not that case.
The primary argument would be by Mr. Mojumdar. By Mr. Mojumdar.
Yes.
And if any additional point to that effect is argued, we will allow you to reply to this. Tell us that. What you have to tell us that.
What? They decided from this side.
I don't know, we have not checked up the order sheet whether you have been added.
Yes. My lord, kindly say can 2, my lord. In the mat. Yes.
Can 2 was allowed by which order? What is the date of the order?
iPad. The first order. iPad. And the other can also, I am appearing on behalf of the. In MAT 873, can
We
2.
don't know, you are appearing for the applicants, which can?
Can 2, can 7, can 22, can 40.
Any one of the cans have been allowed.
Yes, my lord. In the first order, can 2 is
Can
allowed.
2 in connection with which?
MAT 873 of 2023. That means the board MAT.
Board's appeal.
Yes, my
So
lord.
in the board's appeal, you have been
Yes,
added
yes,
as a
yes,
respondent.
yes.
So very good, we will hear you.
Yes, my lord. I am led by
Hear you.
Yes.
Then after Mr. Dotto concludes,
I will satisfy that.
we will, just a moment. Wait, sir. After he concludes, we will hear you and he will give a composite reply to this. Mr. Modi.
Yes, ma'am.
My lord, after Mr. Dotto,
My lord, after Mr. Dotto, Mr. Bandopadhyay would like to make his submissions. It was submitted by him on the last occasion.
Yes. Let him finish, madam.
আমরা করতে পারি কন্টিনিউটি চাই তো আমরা
Keeping it on 12th, but finish it off on that.
Kindly give me 12th and 13th subject
No,
to
no,
your
not
lordship's point.
12th, we request you, please curtail it. You tell us the paragraphs, we will go through the judgments, relevant portions you come back and make an endeavor to finish it off. And we save 12th, and you be ready for your, you people be ready on 12th. We can take it up on as a continuing pattern on 13th and 16th, and you finish it off. Mr. Bolinder, you have not yet started. You start.
I am appearing for one of the employees who have lost their employment. He might not wants the continuity, and day after tomorrow, day after. I can continue the argument tomorrow.
For whom, Mr. Mitra, you are
I can. If whether one's continuity of the arguments before vacation also,
না না জজ সাহেবরা চাইছেন না এখন চাইছেন
I mean, cancel. Who are not parties but employment cancel. They are about 700 in number, so I am concerned. Is the case? If I that one, I can continue tomorrow.
Mr. Mitra, unless he finishes, how can we allow?
That's not give me a choice to your lordship.
Now again, then he will complete it half and again.
No, we shall not. There will be no contradiction.
ছুটি পরে
আগের অর্ডারটা কি দিয়েছিল? Mr. Dotto, please finish it off on.
12 minutes পরে।
Sir, you find it out now. You assist us. You point out the dates of the order. Orders, no, compilation of orders we also have. But the thing is, which order you are referring to? Please check it up. Or Mr. Dotto, the next senior advocate, appearing for the evidence. Is the matter for further consideration? For further consideration on on 12th June as fixed at এই যে জাজমেন্ট দিয়ে করেছে না অর্ডার শিট আর এই কারা কি বলছে তুমি এটা নোট করেছো? অ্যাপ্লিকেশন গুলোর কি আলাদা বান্ডিল আছে? তাহলে ওই অ্যাপ্লিকেশন গুলোকে একটা আলাদা বান্ডিল করে চেম্বারে রাখো, তাহলে দেখে নিতে হবে আমাদের।
বলছে অফিসারকে বললো মনে হলো আন্দামান যাবে
12th June, 12th at
কবে লাগলো?